May I plead your lordship? Your lordship, I beg to mention item number 14, your lordship. Actually, my senior counsel is not well today.
Hmm.
Senior counsel, so may it be please listed on 7th, Wednesday. It's a very urgent matter. Related to
On the prayer of as preferred by MS
B. Soren.
Soren, Learning Council, appearing for a petition. Leave the case on. When is
Wait, please, your lordship. In item 50, we will be filing an additional affidavit shortly that may be called for
item?
50 of the supply list.
Okay.
My lord, I have filed through IAS, my lord. One is for implement and the other is for vacating, my lord. Maybe listed tomorrow, my lord.
Not tomorrow. Maybe Wednesday or Friday.
Wednesday, my lord.
What is the why implement?
Implement because I'm the necessary party, but I have not been.
Okay, Friday.
I take to mention item number 28, my lord, with the consent of the other side, kindly adjourn for the day, my lord. And fixed
Okay,
any other.
Mr.
K. Uddin, my lord.
Uddin, on the prayer of Mr. K. Uddin, Learning Council for the petition, matter stands adjourned for a week. It is submitted that function has been taken from the Learning Council for the respondents.
My lord, a date may be fixed, my lord.
1 week, 1 week.
Another prayer, my lord.
You have informed the other side?
Yes, my lord.
Okay.
Another prayer, my lord, a motion matter, my lord, may be listed on Wednesday, my lord.
What is the subject?
My lord, it is the election of a cooperative society, my lord. Wherein, my lord, our nomination has been cancelled, my lord.
Your lordship, I beg to mention item number 10, kindly adjourn for the day.
You are Mr.
R. Shah, on behalf of PK Roy Chaudhary.
Okay. On the prayer of Mr. R. Sahal Learning Council, appearing for Mr. P.K. Roy Chaudhary Learning Council for the petition. If it's possible for the day. Who is for exercise? Anybody? You have informed the other side?
Not
No.
motion matters.
No, you have to inform.
I will inform.
You don't take it for granted. You wait then, we'll adjourn, and then when the matter reaches.
May I please, your lordship? Lordship, I beg to mention item 23, your lordship. Lordship, in this matter, the pleadings are completed, your lordship. Pleadings are completed, your lordship.
Hmm.
The lordship may fix the matter for hearing, your lord, in any on any hearing day.
Okay, let the other side come. Who is there?
Lordship, I'm for respondent number 2 and 3.
Respond number?
2 and 3, your lordship.
I'm for
And who are the others?
4.
4. No? Maybe in March then.
Yes, your lordship.
March 7. 7 or 7? P.K. Bora,
Yes, your lordship.
petitioner. Any central government council? P.K. Midi. P.K. Midi. Learned Central Government Council for response number 1. MS?
D. Gupta.
D. Gupta, Learned Council for the responding number 2 and 3. And Mr.
W. Ahmed.
W. Ahmed, Learned Council appearing for the responding number
4.
4. Have submitted that exchange of bidding between the parties. is complete. List the case on short by the Learned Council for the parties. List the case on 7-3.
Deeply obliged, your lordship.
DP of Lavia.
May I please, Lordship? Lordship, beg to mention item number 45. Would like to withdraw the matter.
Mr.
B.T. Kakoti.
B.D. Kakuri Learned Counsel for the petitioner has submitted, instruction, that the petitioner wants to withdraw the petition. Full stop. In view of the above submission made by Mr. Kakuri Learned Counsel for the petitioner, the petition is dismissed and withdrawn.
Obliged. Lordship, I beg to mention item number 6. Matter may be adjourned for the day.
On the prayer of Mr.
Ace Islam.
A.H. Islam, Learned Counsel appearing for Mr. B. Sinha, Learned Counsel for the petitioner. The case is passed over for the day. M.S. G. Hajorika, Learned Standing Counsel Revenue Department, and M.S. M. Borma, Learned Advocate Assam for the state respondents are.
My lord, I beg to pay one read petition for listing and in the admission column. Actually, on the last occasion, prior to 5-6 months, one report was called relating to the demolition of the house. Part of the house was done in the national highway. Other part was not calculated. Therefore, order was passed to recalculate. But report is yet not, my lord.
Next week.
My lord.
Wait, please, your lordship. Lordship, my line of friend
You
has.
don't have any mention memo.
It is coming, my lord. Just 1 minute.
This is not the way.
Lordship, my learned friend has made a mention of item number 28, your lordship.
Item number 28.
Lordship, kindly I pray for fixing. I'm appearing for the private respondent, and interim order is also operating, your lordship. Any
Interim
date.
order operating.
Lordship, any date, your lordship.
Style of this, did you release the case on?
Next week, the oblige, lordship.
Interim order passed shall continue. Style of till the next February.
Please, your lordship, I beg to mention one read petition for listing, lordship.
Subject matter.
It is a matter related to non-payment of area rent, lordship.
Also before the registry on payment of area rent. Not that urgent.
Please, your lordship, I beg to make a mention for item number 49 of the daily list. The I is for a minor correction of a typographical error, your lordship, with regard to the assessment here.
We'll try.
Yes, sir.
For motion item number 1.
I'm engaged, my lord. I have seeken adjournment till Friday, my lord.
Till
Friday, my lord.
what is the subject?
That is service tax, my lord.
Service tax matter. Regarding appeal. The petitioner is supposed to file one affidavit.
That also, my lord, I will file it, my lord.
No, non-deposit. Non-deposit.
Free deposit.
Non-pay deposit.
On 9th, my lord.
One to approve.
Okay.
5-6.
Mr. J. Roy, Learned Senior Counsel appearing for the petitioner, has sought listing of the case on 9th. Mr. S.C.
234.
Kyle. Learned Standing Counsel, CGSP. For the respond number 2, 3, 4. A. Sharma.
and 6.
Learned Counsel for the respond number 5 and 6 are present. I have no issue to say there. List the case accordingly on.
Obliged.
Item number 2.
My lord, in this matter, we have received our instructions, my lord. Appear for some time to file our appeal.
Okay. Yeah, then we'll issue notice returnable 2 weeks.
My lord.
Lordships.
Mr. Council, in the show cause notice under section 73,
Lordships.
which is challenged, is the figure telling with the audit
Lordship, figures for
report?
output tax were telling Lordships, your Lordships had taken that care. And Lordships, even subsequently to your Lordship's order, the state of Assam has come up with an instruction dated 26th of December stating that all the cases where audit has been conducted, then the issuance of show cause through this IIT big data software has to be withdrawn. Lordships I can place this Lordships through an application on the next day. I can prepare an application, Lordships, for this. This is a subsequent development which the state of Assam has specifically come up with the instruction, Lordships.
I think you have enacted the instruction.
Lordship, this is post dated. This is dated 26th December, Lordships.
What is the instruction?
Lordship, may I place one copy, Lordship? Lordship, this is dated 26th December. Lordship says, attention is invited to the IIT Big Data software, which has been procured by the Commissioner of Taxes, Assam, for ease of operation for their jurisdictional offices. With the help of the software, automated notices can be generated based on the different parameters. Representations have been received that even though taxpayers have been assessed for cases like scrutiny, audit, advisory, summons, but notices have been issued again in those cases for 1718 and 1819. Considering that in the initial years of GST implementation, a lot of practical difficulties were encountered, it is hereby advised to drop the proceedings, keeping in mind the following. Serial 1. In those cases where audit proceedings have been completed, the notices again given using IIT Big Data software needs to be dropped. This is exactly my case, Lordships. And there are other parameters also for other cases where scrutiny has been done and all those things, Lordship. And Lordship, then serial number 9, second page, Lordships. So after serial number 9, Lordships, may I please? The para after serial number 9.
Yes.
The above instructions shall be followed strictly. The cases where the notices are required to be dropped, then neither any written submission is to be called for, nor a taxpayer is required to be called for any personal hearing. In such cases, proper officers, after recording reasons, shall drop the proceeding on the basis of facts and contents of each cases. A taxpayer must be informed about dropping of the proceedings without fail wherever applicable. Lordship, this is what I rely upon. It's a subsequent development also.
I heard Mr. A. Kanodia, Learned Counsel for the petitioner, and Mr. H. Borua, Learned Counsel representing Mr. B. Gugoi, Learned Standing Counsel, Finance and Taxation Department, for all the respondents. Also, Mr. Kanodia, Learned Counsel for the petitioner, has submitted that the case of the petitioner will find support from instruction number 13/2023, that's GST dated 26 December 2023, issued by the Government of Assam, issued by the Office of the Principal Commissioner of State Tax, Commissioner of Taxes, Assam, Government of Assam. Mr. Borua, Learned Counsel appearing for the respondents, has submitted that instructions have been received to file counter affidavit on behalf of the respondents, and the counter affidavit will be filed within 2 weeks' time. Issue notice returnable on 28 to 2024. The respondents will also obtain instruction as to whether, so the counter affidavit to be filed by the respondent shall also reverse as to whether the case of the petitioner is covered by instruction number 13/2023, that's DST dated 26/2023. post of interim order possibly. Sir, continue, fill the next paper.
Just a small accommodation, instead of 20th, can you get 26th? Lordships? If subject to your lordship's convenience, otherwise, wait. Grateful to your lordships. Hello, Bill.
I don't know what three.
Wait, is your lordship. Lordship, the petitioner's son, Malad, expired in an untoward accident. Malad, here the claim.
Son?
Yes, Malad, the petitioner's son's expired. While Malad, he was riding his bike to a road. Malad, here we are seeking monitoring of the court as well as Malad, that ex gratia payment against this person.
Seeking, but
Malad, seeking compensation. Your lordship may kindly turn up to the FIR, Malad. That is the page number 52, Malad. Malad, what has happened, Malad, the person who is the deceased over here, he was riding a motorcycle on the road. Malad, what was required, that safety measures ought to have taken by the state respondents while
the undersigned here will inform you that it might. Do you have a typed copy of this FIR?
yes, Malad. Yes, Malad, I have. I'm supplying. Look at page 52, 53. Malad. If I may read. Malad.
Now, 53, you have said that the construction company is solely responsible.
Yes, my lord. My lord, here
In
the
the
PWD main.
in the FIR.
In the FIR. My lord, might kindly turn up to the forwarding report. My lord, what has come out is something strange. Page number 60, my lord. Annex 23. If I may read, my lord, brief history. The brief of the case is that on 23/10/2022, about 6:30 a.m., complainant's son, namely Ajit Kumar Jha, 20 years, met with an accident at MG Road near Machko ITA. While Ajit Kumar Jha, along with Prabhat Kumar Trivedi, was coming towards Pan Bazar from Bhorlumukh side by a motorcycle. The road was closed by a rope by the construction company under Sri Harshajyoti Besho, contractor
Whether it
PWD.
resulted into any charge sheet,
No, my lord, till date, no charge sheet.
because question will be disputed questions.
Lord, disputed question
On the
is
basis of this,
forwarding, Lord.
forwarding is not,
Lord, that is not.
it is
but
matter only for ground of arrest.
grounds of arrest. That would be, Lord.
That,
If I may take-
firstly, there was existence of a contractor,
correct, my lord, that
and that
First of
maybe state, maybe the principal.
principal
maybe-
employer is, my lord, he PWD contractor, my lord.
High concept of vicarious liability.
Yes, my lord.
Question is,
My lord, here we are seeking that, my lord, that should be under the monitor of the High Court, my lord.
oh no, absolutely not.
But
We
because-
are not monitoring investigation, mister. You go there, 156(3). We are not here to monitor.
my lord, then the ex gratia compensation and liability of these contractors would, my lord, attack them, that, my lord, they should. be-
One thing that your petitioner's son
Yes, my lord.
died in a road traffic accident
Correct.
at a public place.
Public place, my lord. That-
There is a notification of the revenue department
Correct.
fixing ex gratia
Ex gratia.
of a certain amount. Your reputation is not structured in that manner.
Right.
Right? Even though it is not structured, it can be, say, molded. But question is, directing an inquiry in such kind of matter, I don't think it is. FIR has been registered. Police is investigating.
Yes, my
It
lord.
is the domain of the police authority to investigate. If you are not satisfied with the investigation, you have many other procedure placed in law, which you have to,
That we can avail, my lord. But my lord,
that is one. And so far as on the aspect of damage, you have to establish. Read proceeding is not yes. What is that? Strict liability.
strict liability, my lord.
Absolute liability. So this is read proceeding is not generally taught. Yes, public remedy. So far as public remedy is concerned, that ex gratia notification is in place already.
Lord, maybe my lord, I was not aware.
Initiate an inquiry for such kind of every day. Such kind of incident occurs. If you go by Sakari Bosu and all other judgments,
Yes, my lord.
if this kind of repetition is to be entertained,
Yes, my lord.
the High Court will be flooded with thousands of
Yeah,
petitions
Lord,
of
it will
this
go
kind,
in a floodgate, my lord.
and which should be stopped. Which should be nipped at the bud. Yes, if you want ex gratia to be considered in terms of the notification, we can
My lord,
examine that aspect.
my lord,
But
that will be. Only that particular lord.
directing an inquiry, all this, and so far on thought, you can very well approach the civil court.
Correct, my lord. That for compensation we can always, because my lord, there are judgments
so
of
far,
the Supreme Court.
Ex gratia in terms of public law remedy, yes, it can be examined in terms of the notification 15 lakh. No more than that.
My lord,
Rare
six
one,
months as well.
directing inquiry, we are not inclined.
Maybe, my lord. So my lord will rest.
See, to monitor in a time-bound manner, we are not in.
No. Then your lordship may direct that, my lord, at least that ex gratia part, my lord, that can be looked into by
Yes,
respondent.
Yes.
PDCL has been included as a party respondent.
My lord, the cause is that, my lord, at that point of time, we
Huh?
were informed that the
APDCL,
work,
why?
my lord, because at that
I
point
don't
of time, the work was going on in respect of some electric connections, my lord. What we were informed, my lord, for that reason, my lord, we have made them a party as well. Under the PWD contract, some electrical works were going on at that stage when the accident occurred. So that was the reason we had to make them a party.
And molding it really will be very difficult.
And in fact, my lord, in this
It's a
petition,
burden everywhere. Revenue
revenue is
should
not
be
a
made a party.
Yes, my.
Lord,
The
that case,
deputy commissioner may remain. He may be
To
the
withdraw and refile it in. a
person who can
document.
inquire into it.
Yes.
my lord,
As
then
per the
the-
notification.
then, my lord, we
Officer
may-
in charge is also okay. But contractor, a public law remedy, I don't know, an APDCL.
so my
their
lord,
presence-
here we will implement the director of revenue, my lord.
Hmm?
The deputy commissioner revenue, my lord, will.
Your revision is to be restructured every year.
So my lord will withdraw then file.
I think
refresh.
better.
My lord, because
If
this
you
revenue
don't
has
have
to
the
be made a party.
notification, get it from MS Bormon.
I'll provide.
And your remedy before the
Civil,
civil court is always there
always there.
on the basis of proof.
Yes, my lord, we'll have to make substantial ground.
There is no limit to ask for any.
compensation. only.
Mr. Betala, heard Mr. Betala, H. Betala, Learned Counsel for application. MSM Bormon, Learned Junior Government Advocate Assam for the respondent number 1, 2, and 4. And Mr. KP Pathak, Learned Standing Counsel, APDCL for the respondent number 3.
1, 2, and 5, my lord.
1, 2, and 5. Mr. Betala, Learned Counsel for the application has submitted that the petitioner wants to withdraw the petition with a liberty to file appraise. The prayer made by Mr. Submission made by Mr. Betala is not opposed by the learned counsel appearing for the respondent in view of the above submission made by Mr. Betala. Learned counsel for the petitioner, the petition is dismissed on withdrawal from with the liberty to file appraise.
I'm obliged, my lord.
Item number 4.
Yes, madam.
Yes, that report has come, my lord.
Court has come. Mr. Dole, one Lamding police station case number 131 stroke 2023, right?
Registered on 9.
That was succeeded already on 36 2023. Sarcid number 125 of 2023, succeeded on 36 2023, right?
I have to go through it. I have to go through it, Lordship. The rest are not, Lordship, registered.
One complaint was on perhaps 29/5.
29.
Whole AGP office Lamding located opposite Lamding post office, which was forcibly locked by Dibakar Nath and Joyanto Das. Lamding PS non-FIR case 29 stroke 2023 under section 107 CRPC. It was registered and sent to DC office Hojai for further action. Your 8/6/2023 FIR has been registered as Lamding PS case number 160 stroke 2023. Right. This instructions received are exhaustive. You may file your affidavit. Then we'll. They have dealt with. Right. Mr. D. Dole. Counsel for the petitioner. Any central government counsel? Whose name can be recorded, Mr. Forman?
Mr. Medhi was there.
Learned central government counsel for the number 1 and MS.M. Mormon. Learned junior government for the respond number 227. Mr. Dole, we are not considering prayer C.
Lordship, a third prayer, Lordship, I am abandoned, Lord.
Because we don't like Because that is a statutory body.
Lordship.
They are conducting
Lordship.
their own proceeding. We will not like to superimpose over there.
Lord. ARC.
Because there are chairman, members functioning there. Mr. Dole, learned counsel for the petition has submitted that the petition is not pressing. Petitioner will not press. Prayer C made in the writ petition, which is with regard to a complaint filed before the Assam Human Rights Commission. Thereof, in deference to the order dated 24/01/2024, comma, MS Bormon, has submitted that instructions had been obtained in reference to the order dated 24/01/2024. MS Bormon has further submitted that the same will be brought on record by way of an affidavit in opposition. Instruction will be received from the office of the
SP office.
respondent number 6. In deference to the so and so, will be brought by way of an affidavit in opposition within 2 weeks' time. Within 2 weeks. On perusal of the instructions placed, do you have a copy?
Yes.
Instructions placed. Instructions contained in a communication bearing memo number so and so dated 2/2024. Comma, it appears that on receipt of the affairs stroke complaints mentioned in the order dated 24/1/2024, comma, investigation stroke inquiries were initiated. Matter would require further examination. Issue notice returnable on 3/30. There are some land disputes, it appears.
Is by 107 proceeding it.
4/3/2024. As Mr. Medhi, CGC for 1 and Hormone for 2/7. No formal notice. Why this MLA?
Lordship, on his instruction, all this appearing, Lordship. There's a liability, political liability.
The petitioner shall take steps for service of notice. The respond number. Then register post and it will be 4 weeks. 11. 3. Upon respond number 8 by register post PKD within 2 working days. The state respondents shall file the affidavit in opposition or not before the returning.
My lord, obliged.
Item number 5.
May I please? My lord, on the strength of the complaint filed by the petitioner before the, my lord, state level police accountability, my lord, they have passed some order. We have been informed, my lord, that has been, my lord, not before this honorable court. So, my lord, we have been instructed to do this case with the liberty to file a fresh. If advised.
Because otherwise, that is a statutory body. They function. We do not have to final order passed. Yes. By that commission. Yes. But monitoring the activities of that commission, that is a bit too far.
Now, since final order has been passed by the, my lord, accountability,
Then,
so we have to.
it is up thereafter, you can, yes, agree by that, you can
My lord,
do it. But something is pending there. It is a statutory body. It is functioning. Right?
That's
It is proceeding with a matter. Then you file a writ petition to monitor their activities. That is okay. Final order first, you can.
yes.
Mr. M.U. Mondal and a council board of petitioner has submitted that the petitioner wants to withdraw the writ petition, with the liberty to approach again in the event of subsequent cause of action. Full stop. MS M. Mormon. How many? All.
1, 2, 3, 7, 8, 9,
1
10.
to 5. 1 to 5. 7, 8. 9, 10.
11, 12.
11, 12, 13. 13. 13. Huh? 1 to 5. 7 to 13. Huh? Is present. In view of the above submission made by Mr. Mondal and a council part of petitioner, the writ petition is dismissed on withdrawal with a liberty as per.
Item number 7.
Yeah, please, Your Lordship. So this is an application for appointment of arbitrator.
Arbitration. Yes, central government. Or are you railway? Do you handle?
Yes, Lordship.
Heard, Mr.
A.A. Ahmed. A.A. Ahmed.
A. Ahmed, Learned Counsel for the petitioner. And Mr. P.K. Mehdi, Learned Central Government Council, for the response number 1 to 3. This is an application under section 11 of the Arbitration and Conciliation Act 1996, seeking appointment of an arbitrator in respect of disputes, so differences arising out of contract agreement number so and so, post that is second dated 16/9/2008. As Mr. issue notice returnable in 4 weeks, as Mr. Mehdi, Central Government Council has appeared and accepted notice for response number 1 to 3. No formal notice need to be issued. However, extra copies. The petitioner shall take steps for service of notice upon the response number 4 by registered post utility within 2 working days.
Item 8.
May please, Your Lordship. Lordship, I have applied the certified copy, but not yet received. Can Lordship be fixed from other day?
You want what relief?
Lordship only relieves Lordships that crops has been, because Lordship last occasion Lordship has mentioned, because Lordship,
Otherwise, it is criminal jurisprudence,
yes, Lordship.
right? It is, because
Being
that-
Lordship,
that-
I have also studied after Lordship's opinion.
because
Lordship-
this judgment.
And Lordship, I utter some words. Lordship,
this-
when this matter was came before trial court filed a criminal revision. But the dispute is civil nature. But
No, dispute is civil nature. Dispute is arising out of section 107, 145, 1.
Absolutely, absolutely.
That is under Code of Criminal Procedure,
Absolutely.
right?
Yes.
Against any order passed by the authorities there,
Yes, Lordship.
right?
Lordship.
District magistrate or any, whatever,
Lordship,
sub-regional
Lordship,
magistrate.
Lordship,
That is within the criminal jurisdiction,
Lordship,
right?
Lordship.
So a
Lordship.
revision will lie before
Lordship.
the
Agree, I
Session
agree,
judge.
I agree, I agree.
right. District and session judge, he has both jurisdictions, civil jurisdiction as well as criminal.
Absolutely.
Any revision lies under CRPC,
Lordship,
right?
Lordship.
Then, if any order is to be challenged, passed by the session judge in the criminal side, that has to be either by 482 or writ
397 included.
writ petition criminal.
Absolutely, absolutely. I agree. Now, what is in my mind, Lordship?
Ah.
Because in the last occasion, because I have to brought the fact before the court, the transparency of the court, because on the original case has been filed before the case is 26, 27. Original case. So, Lordship, at present, my only relief I want not in land, because land in Patta is in my name. They have neither challenge, neither they have and the forest also. Court pass an order, direction given.
Right, Mr. Sur. This has to be either writ petition criminal or
Yes.
482.
Lordship.
This has been registered as writ petition civils. That is the
Yes, I agree.
difficult-
I agree. I
That
agree.
is the difficult.
Lordship, I agree, Lordship. But the relief,
been-
what is in mind, relief, because the relief is in civil nature.
No.
Agree,
Uh,
Lordship. Lordship agree. Can
don't-
Lordship, I'm not
See-
having any dispute because when the case been filed, I am outside the state. So I have what I have in my hand, I have to utter before this court.
Right.
I have
understand.
my legs in very limited. So what is my humble submission, Lordships? There is no dispute as such. Title is in my name, and forest to pass an appropriate order. That order passed by the trial court.
So
Let either forest pass an order with a time bound, or the crops has already been completed.
No, Mr. Sur, you are not understanding it. This session judge has passed the order exercising criminal jurisdiction.
Absolutely, absolutely. I agree, Lordship. I agree.
Against such order, you have to prefer either a revision under 401, read with P97 before the High Court, or maybe under 482, or
397.
maybe a writ petition criminal.
Lordship, I agree. I agree.
And if that is not registered as either of these three,
I agree.
I do not require to pass any order.
Lordship, I agree. Can Lordship?
That is a difficulty, Mr. Sur.
I agree, Lordship. 100% I agree. I 100% agree. I am not on.
I am not
superintending power.
be able to pass any order.
Lordship, what I want before this court, Lordship, very humble request. I agree because it is. I have filed the superintending power of 227.
I will not change my own order. When the lawyer makes the default, I will not pass any order to register it as a writ petition criminal.
Lordship, now Lordship
Make
can
an
do.
application.
Now Lordship can do one thing. Let the certified copy I will bring and fix and accordingly, Lordship. That's my humble submission.
That may be a immaterial thing. Because that day you relied upon that. Which
No,
is,
I not rely on that. That is one of the ingredient. I rely only the patta in my name. Only my reliability. Because it is 74 and 76, my patta is in my forefather name. On
But-
the basic of that patta, I have in my land.
Mr. Sur,
Can Lordship without cancelling that my patta?
Mr. Sur,
Lordship.
page 44. Page 44. After discussing the evidence, learned session judge has said in paragraph 11. Thus, from the above evidence on record, it has come to light that names of both the parties appear in respect of the disputed land. Next, The parties are fighting each other, claiming their absolute right over the disputed land. It appears that the forest authority is the best department to deal with the said land. Thus, the additional district magistrate has no power to put either party in position till the title is decided by the appropriate authority. He has not decided the title issue of title in your favor, nor in favor of your opponent. He has said that forest department is the best authority and additional district magistrate has no power. This is to be tested in a
Lordship, this is
in a
his
proper
observation. Lordship, this is his
petition.
observation. With very humble submission. Lordship, on record, I have annexed in 74 document and 76 document.
We are not here, Mr.
Any, Lordship, anyway, Lordship, anyway.
We do not decide title in a writ petition. We only test the validity of an order in certiorari jurisdiction. But this is not the petition. You should have filed 482 or criminal revision, criminal petition, criminal revision, or writ petition criminal, not writ petition civil.
Lordship.
That is what I am
I agree, Lordship. I am not denying.
emphasizing.
I am not at
Mr.
all.
D should
The
understand
second opinion, I have agreed.
Wait for listing of the
Lordship,
case.
but
How much?
I agree, Lordship. But 227 is finally it is superintending power. Finally, when?
Mr. When the very order, Mr. Sur, when the very order is passed, exercising jurisdiction under the Code of Criminal Procedure 1973, things cannot be transferred to CPC. 227? Yes. Then 227 has to be registered as per law, CRP. But that is civil revision petition. 227, yes. 227, read with 401, 397. That will be registered as criminal revision petition. Mr.
I have not accepted that. My problem is because because I am not arguing, Lordship, I am just submitting. So at the moment, because the original petition, writ petition 227, I have bonded on that.
No, I am not here in a law college. Mr. D. Should learned counsel for the petitioner has paid for listing of the case after 2 weeks. Place the case accordingly after 2 weeks. We are not here in law college.
Okay, all right. Then number 9.
May I please, Lord? Proceed this petition by the Chief Commissioner CGST against the order dated 26/7/2023 passed by the controlling authority under payment of gratuity act. Lordship, after receipt of the notice by Annex 2.
Where is the order?
Order is at page 16. Lordship, by Annex 2, we raise preliminary objection that our department doesn't fall under the industrial laws.
If payment of gratuity?
Yes, Lord. And Lordship knows this is an indirect tax department. Our function is to collect taxes.
You are an arm of the central government.
Yes, Lordship.
Okay.
So we cannot.
Now, does it come within the definition of establishment?
Lordship did not fall under that.
How?
Because I have not said so, Lordship, it doesn't fall under any of the industrial law.
No, this is not a case of industrial law.
No, Lordship, please.
Here, definitions are provided.
Yes, Lordship. Industry.
Suppose appropriate government means
Central government.
in relation to an establishment belonging to or under the control of the central government. The central government. Right. This is belonging to or under the control.
Under the control.
There is no doubt about it. Is it? Now, question is whether it comes within the purview of section 1(3). What is the interpretation of Supreme Court?
Lordship, in 2 other cases, in 1995, Supreme Court is the Central Groundwater Board held not to be industry. And even
No, it is passed under what act?
Industrial Dispute Act.
Ah.
No, Lordship.
Don't bring Industrial Dispute Act to a case under Payment of Gratuity Act. Tell me any authority on Payment of Gratuity Act.
Lordship, I didn't find any authority.
There are
particularly
Supreme Court judgments
on Gratuity Act. Lordship,
on Payment of Gratuity Act. Yes, yes. Tell me whether this, he was what? He served for 28 years.
He was casual worker. Lordship, what
appears-
happened about?
No, having regular pay scale.
No, Lordship. Lordship, this is the difficult end. Lordship, what happened? There are about 15 employees were there. Out of then 6 or 7 they approached tribunal and rest approached the CAT, Lordship. Central Administrative Tribunal.
Just 1 minute. Do you have the act?
Lordship, we check, Lordship.
Payment of gratuity.
Lordship, I will. Lordship, may I please to see our objection, Lordship. Page 15, Annexure 2. And paragraph 1. Effects of the Central Board of Indirect Taxes and the Custom is a government department under the Ministry of Finance, Office of the Sancho. It is subordinate to the CBIC and clearly beyond the purview of the Industrial Disputes Act. Therefore, the department cannot be termed as industrial establishment undertaking, and as such issues sought to be raised by the waiver cannot be termed as industrial dispute. The following. Then
Mr. Kyle, your department is arguing the case from the standpoint of Industrial Disputes Act 1947
Lots.
and from the perspective of industrial establishment.
Yes, Lord.
In Payment of Gratuity Act, it is not industrial establishment, it is establishment.
Lots.
And Payment of Gratuity Act, I think employees definition, if you see, employee means any person other than apprentice
Yes, Lord.
who is employed for wages. The terms of such employment are expressed or implied in any kind of work, manual or otherwise, in or in connection with the work of a factory, mine, so and so, or other establishment to which this act applies, but does not include any such person who holds a post under the central government or a state government. This is one condition. Second condition,
Lots.
is governed by any other act or by any rules providing for payment of gratuity. If he is,
Yes,
if he is not under any other rule providing for gratuity, perhaps he may fall within the definition of employee.
Lordship, here in this case, they are governed by the rules of the department.
That is what I
Even-
am asking, whether this employee is governed by that rule or not. If he is not governed, but he has rendered 28 years of service,
No, definitely.
is he not entitled for gratuity?
No, we are not disputing that aspect of the matter, Lordship, because in CAT case are pending, we file our reply also. But our contention before the authority was that because he is not an industrial worker and we doesn't fall under the definition of any of the industrial.
We are dealing with Mr. Payment of Gratuity Act.
Lordship, this is also because the definition this Lordship has read out, probably the department will not fall under that. And they are governed by.
Kyle, please go through even there are, it has been interpreted. Suppose an employee under central government or state government, he is covered by any other gratuity rules as per the service rules.
Yes, Lord.
Okay. He will not come within the purview of Payment of Gratuity Rule 1970.
Yes, Lord. This is our,
Right. This is one aspect.
this is our contention.
But if he is not covered,
They are covered, Lordship, because CAT is entertaining.
then you so
I'll-
because your page 15 reply is wholly in connection with industrial dispute.
Yes, Lordship, because notice issued by the controlling authority on that aspect of matter of ground.
Let us see the notice.
One, Lordship, Annexure 1, page 10. Where Sri Tapan Kumar Paul pressure, casual worker, regular basis, আমার বাচ্চা লোন চঞ্চল, an employee under you file an application under sub rule 1 of section sub rule 10 of payment of gratuity act or non-payment of gratuity made by you to Sri Tapan Kumar Das. Now, therefore,
In the notice itself, Form O, notice for appearance before a controlling notice.
yes,
A
Lordship,
controlling notice under the payment of gratuity act
Gratuity Act.
1972.
and we appeared and we filed a preliminary objection. That was not decided, Lordship. If that could have been decided,
Not required to be decided.
Lordship,
Your whole application is structured on Industrial Disputes Act.
Lordship, may see the last 3 lines of page 15. In case you are not in agreement with the department's view, you are requested to provide document data information submitted to the applicant so that the department is able to submit further written submission to your office. Without considering all these things, Lordship, final order was passed, directing us to pay.
On page 17, hearing was conducted as provided in Rule 11 of the payment of so with both applicant and the respondent. Okay.
Approximate authority was not there before the controlling authority.
It was ex parte.
Lordship, it was ex parte.
Is it your case that it is
No,
ex
no,
parte?
No, we said that our preliminary resolution was considered and final order was passed.
If it is a case of ex parte, that is a different thing.
Lordship, we are not heard. And Lordship, what happened? There were 17 employees were there.
No, you have submitted your
Preliminary objection.
objection.
And we requested that if the authority is not agreeing with our contention, so opportunity was given to us so that we can file our detailed reply. On merit of the case, nothing was there from part of the department before the authority. When Lordship, Central Department.
Because Rule 11 permits filing of application to recall an order of ex parte. Right, which you have not done.
We have not done. Lordship, what happened after?
These are the, I am pointing out the
No, Lordship, we have not.
issue.
Followed. Lordship, what happened after passing this order? They issued a recovery notice on the department. Also after filing of the writ petition. Lordship, we are on merit, we are not denying that they are not entitled to. But regarding the forum, Lordship, out of 17 employees, about 10 employees has approached learned CAT, Lordship. If they are legally entitled, Lordship,
CIT, why they are CIT?
Lordship, because under the central administrative law, all the central employees, they have to file.
I think this man has correctly approached
Lordship, out
the
of
forum.
17 out of 17.
17 may be on wrong advice, the others 16. This man has correctly approached the forum, it appears. See the rules. First, you tell me or satisfy me that
I'll produce the rules.
central, it is there.
No, our rules.
If you have
Yes, we have.
any gratuity rules and this man comes within the purview of those rules, then yes, okay.
Let's me take up day after tomorrow. I'll
then okay.
Basically, this is our contention.
If this is fulfilled, that you need to see also section 5.
Lordship.
If suppose you have, then exempt, there is power to exempt, then section definition providing for employee, employer, and application of the act.
Lordship, with regard
It appears
definition of industry and workman, it is the same with the industrial dispute act. The definition of worker.
you are, Mr. Kyle, this covers everything. Section 1, subsection 3. Every shop and establishment. We need the meaning of any law. Right. For the time being in force in relation to shops and establishments in a state in which so and so so. It shall apply to so and so. The definition of establishment have been interpreted
Lordship.
by Supreme Court
Lordship.
in 70s, 80s, 90s
Lordship.
already. Central government establishment, yes, it is an establishment,
But Lordship,
which comes under the purview of Payment of Gratuity Act if the employees there are not governed by any other gratuity rules
gratuity rules.
under their service rules.
I'll produce on Wednesday. Lordship.
All these decisions are there already. 70s, 80s, 90s issues are settled.
Lordship, one. With
You are
respect-
arguing the matter from the perspective of Industrial Disputes Act. No.
No, Lordship, what happened with regard to registered under the shop and establishment, they are not required to. The particular department, the GST department is required to register under the shop and establishment.
All those have been interpreted. Many
No, no,
judgments.
Lordship,
Many judgments.
I'll produce the rules. Unfortunately, Lordship.
Travel to 70s, 80s, and 90s. Those are still holding the field. And this is not with regard to only Industrial Disputes Act, workman.
No. The person, Lordship, who has approached the tribunal, he doesn't fall under the definition of workman under any of the industrial disputes.
So what ground you have taken before the Industrial Tribunal Act?
That-
That they are not workmen?
The department doesn't fall under any of the industrial.
Right.
This is not a contention.
There you have taken the stand, they are not workmen.
And and
See, Mr. Kyle, there 16 persons have gone there. And you have taken the stand perhaps that they are not industrial workmen. Where do they go?
before the CAT,
CID means what?
Central Administrative Tribunal,
Industrial?
Central Administrative Tribunal.
When a statutory authority has been given the power.
Let's say I'll produce.
After the order, yes.
Our rule will clarify everything.
You can argue one thing that this should be decided by CAT. If that is argued, then this petition is to be filed before the CAT.
Now, we taken that simply one point that our department doesn't fall under any of the industrial law because our sovereign function is to collect taxes. And in about 4 judgments of Supreme Court, Census Department, PWD, irrigation, they were declared to be not by industry. Under the,
That is what I am
Yes,
asking.
I-
Sir
I-
Kyle.
I got.
This is not related to industrial workmen.
I'll produce the rules. That will clarify.
This is not related to any employee. Not related to.
But exception probably is applicable. Exception is applicable.
Come up with authority.
I'll-
These high court authorities will not do.
No, Supreme Court, let's see.
This you have cited in paragraph 15.
Let's see, in that
I don't
judgment,
think.
there is a reference of two Supreme Court judgment also. I know with respect to one is with respect to Census Department, one is PWD, one is Irrigation Department.
There will be slight distinction.
No,
Postal department also, this Gram Sevak, right? He filed a petition for gratuity, then said that department has a separate gratuity rule. So he's not come under payment of gratuity.
I'll produce the,
In that manner, Vijay, come up.
yes, I'll produce the rule that.
We'll learn.
Yes, no.
On the
definitely.
prayer of Mr. S.C. Kyle and a council for the petition, laid the case when
Witness,
Wednesday, Friday? Friday? Morning.
yes.
Morning, there was a prayer, you were not there. For adjournment.
Okay, Lord.
On the, Mr.
Arsha,
R. Saha, Law and Council appearing for Mr. P.K. Raichuri. And Council for the petition has sought an adjournment. Mr. R.I. Gogoi,
Excise.
Law and Standing Council Excise Department.
Respond number 1, 2,
For all the respondents,
No.
right?
3 they have.
1, 2, 4 and 5 and MSM on Junior Government Advocate Assam for the number 3 are present and had no objection to 6. So matter stands, the case stands accordingly passed over for the day.
Public.
May please, your lordship. Lordship, this petition relates to lordship refusal by the subdivisional officer, Sodor Saraideo, to supply the certified copy of the case lordship to the petitioner. And she refused to accept the council lordship of the petitioner engaged by the petitioner.
Prayer?
Prayer lordship,
Fall for the record issue, so called.
to supply the petitioner the copy of the complaint, any complaint petition lordship and orders passed by the SDO Sodor lordship.
Yes, Miss Mormon. For this kind of prayer, repetition.
In fact,
Unfortunate such
Lordship,
statement.
that is how lordship started this petition.
and paragraph 5 onwards, my lord, I found that all allegation against the respondent number 4, my lord.
Who is respondent number 4?
Says that
SDO lordship.
SDO civil Sodor for IDO.
Huh.
And in that case, probably she might have named by name, my lord. If any personal allegation, my lord. Paragraph 5
We are
reflects.
not here to decide all these. If
But
certificate
for
copies
his-
are furnished,
These are petty issues,
petitioner
my
will
lord.
not have any further grievance.
Lordship,
Will not go into who is the subdivisional officer, why she is disturbing.
To 26, it's not applicable. To 26.
Can
it's
you
not.
make it possible?
I'll try. and-
We also like to resolve some
Yes,
issues,
my lord.
though
But delegated
filing of
stated,
this kind of repetition is not
Yes,
very
my lord.
appreciated still.
I'll make it try, my lord. 2 weeks.
What do you want, certificate copy or normal copies?
any copy lordship, I am in dark lordship, what complaint?
You are
is
in
filed?
dark.
Some
So-
complaint has been raised by the private respondent that copy document is not given to her, my lord. That is her.
What was the case?
Nothing has been stated.
Lordship, nothing.
What was the case
Doesn't
or what?
have the copy.
Who instituted the case?
Lordship, one Srimati Sulema Khatun. Lordship.
Lutfur Rahman. You are Lutfur.
Yes, lordship,
You are Lutfur.
lordship,
One Sulema Khatun.
yes, lordship.
Notice of hearing.
Nothing is given in the lordship. It is not clear from the notice also, lordship.
Yes, this SDO Sodor have not registered any, has not registered any case.
Some miscase is raised.
Page 17. Where is the miscase number? Where is the miscase? Page 17.
Only notice number is there.
Page 17.
And subject is also regarding notice for hearing.
Notice for hearing. What kind of, this is totally vague.
Yes, my lord. Doesn't reflect anything.
Anything.
Anything. Only appearance date is there.
One cannot ask for a personal appearance like this.
And she also refused to accept the wakalatnama lordship filed by the council.
That should not be.
This is something going beyond.
Yes. my lord. Seems true.
Take your instruction if the petitioner's only grievance is that the basis on which she has been asked
for.
to appear is not known to her. So there must be some petition
Obviously,
or application by Sulema Khatun.
yes, my lord.
So at least the copy of that petition
That should be provided to her,
So I will keep this only in the motion.
my lord.
You better know how to
Yes.
write the letter to the
Yes,
subdivision
yes.
office.
I'll do.
Lordship, in that event, Lordship, proceeding may be says.
Oh, no.
Lordship, next day.
Mr. Bormon will
That
ensure about,
I will verbally inform.
Miss Bormon will ensure.
Nothing to be written.
Lordship.
Heard MS R. Gogoi learned counsel for the petitioner. ZAD, you appear.
No, my lord. P
MS.
Nayak is there. P
P.
Nayak.
Hajorika, P. Nayak, Mr. P. Nayak, learned standing counsel ZAD for respondent number 1. Z. Hajorika, Revenue 2. And MS M. Bormon, learned Junior Government Advocate, Assam for respondent number
3 and 4.
3 and 4. Full stop. MS Gogoi, learned counsel for the petitioner, has submitted that the petitioner has been served with a notice dated 2/1/2024 in bracket next up 4/1 by the respondent number 4, whereby the petitioner was asked to appear before the respondent number 4 on the date mentioned in the notice. Full stop. As the notice did not reflect under what provision of law the hearing proceedings was initiated, nor there is any case number. The petitioner applied for certificate copies of the application if any of petition if any submitted by the opposite party, first party mentioned in the suit notice. The name of the petitioner was shown as the second party in the same. As the petition was not furnished with the application, petition, etc., on the basis of which the notice dated 2/1/2024 was issued, the petition is before this court. By this state petition, MS Bormon, learned Junior Government Advocate Assam, appearing for the respondent number 3 and 4, has submitted that suit make endeavor to obtain necessary instructions from the respondent number 3 and 4 within a week's time. To stop as sought for by MS Bormon, release the case on. Tell me.
Next Monday, my lord. Next Wednesday, my lord.
Okay, Wednesday. Holiday.
Sorry, my lord. 16,
16th?
my lord.
Raise a case. And ensure don't proceed.
Yes, I'll.
Number 12.
Well, I'm a businessman having a trade license, and there is a regular transaction in with the Central Bank of India, Nagaon branch. Well, suddenly, my lord, branch manager has defreezed my account with the allegation that I take your lordship page 15, my lord. 15. Complaint and additional information, financial fraud of rupees 5,000.
Then
Date is
8/5/23.
8/5/2023, my lord. 8/5/23, page 17, my lord.
8/5.
Page 5, your lordship will find.
Page.
Page, initially page
Okay.
15, my lord.
Account credited.
Complaint, kindly come to complaint, additional information, financial fraud of rupees 5,000.
Page 15.
15, my lord.
Fraudulent transaction details.
Yes, financial fraud of rupees 5,000. Now, my lord, I have got a full bank statement. then kindly come to page 17, my lord.
What is page 17? Yeah,
Page
Mark.
17, account credited to, this is the account number, my lord, my account number,
Your account is at which bank?
Union Bank of Nagaon.
Union Bank of Nagaon.
Nagaon.
What is this document? Citizen Financial Cyber for Reporting and Management System. Is there any system?
Yes,
Okay, you can get it.
yes, they have supplied us copy.
Okay. Now come to page 17.
Page is, my lord, your lordship will find my account number 4675020111 such and such, my lord, account number.
Ending with 289.
Yes. Then transaction number is 31 28 24 28 09
955.
This amount is 20,000.
20,000.
Yes, that is right. That day, and then next bank statement will ensure, my lord. Page 19, you will find
19.
bank statement.
Hmm.
Under the same transaction number,
Serial number 467.
serial number 467, kindly see, my lord.
467.
Yes, the transaction is 20,000, not 5,000. That is credited in my account. Under Google Pay, my lord, nowadays people are paying my amount because I have got a grocery shop. Wholesale business is also there. The question of fraud transaction doesn't arise, my lord, for which my account has been seized. I am
You
not.
are Lilima Begum.
Yes, Lilima Begum.
You are in grocery business.
My husband.
Huh?
My husband name, my lord. I have annexed the license, my lord.
Joint account or what?
Not joint account, but bank operation number is my wife's, my lord. State license page 14, my lord.
Yes.
My lord, in this case, no,
It is in which district?
My lord,
it's
Bor-
Borpeta, my lord. But
Borpeta.
petition seems, my lord, no police case has been registered.
no police case registered.
Huh?
No police case. Bank is not paying. I have made an application, my lord, to page 21. I have made a representative to the bank. Kindly release the difference the
Bank
account.
authority must have answered, my lord, in that matter.
No, Mr. Mormon, please see. Page 15. Complaint currently with police station.
Yes.
Name, OC Borpeta. Page 15. One is complaint and details, some Ripon Kolita.
Yes.
Yes.
Right. Next, complaint currently with police station. Name, OC Borpeta. Designation, police inspector. Mobile number is also given.
Yes.
Email, SP Borpeta. Have you made a SP Borpeta party?
I have made party, my lord, officer in charge,
Officer
Borpeta,
in charge is.
deputy inspector of police, then director general of police, branch manager of the Union Bank.
So mobile number is given. So there must be some complaint. On the basis of which.
But the statement has been given by the bank. There, your lordship will not find that I have frauded any account. 5,000, I have not frauded. There is rather than 20,000 is credited in my account on the same serial number, same number.
Let us get the instruction.
From SP.
There is a procedure to be followed for attachment or deep freezing of an account.
Yes, exactly.
Under CRPC,
Yes.
102.
They are not doing it, my lord.
And that has to be
Bank has, they are because
immediately.
probably OC might have told the bank manager, don't. That is-
Phone number, over phone.
Yes, ma'am.
Yes, shall we issue notice?
I think notice may go, but I have to take instruction if lordship want a short
as per our
instruction.
code.
then Yes, my lord, after 2
If-
weeks.
Say, if it is in connection with
Some complaint.
any police case,
Yes.
right, first,
Yes.
then there has to be proper application under section 91 perhaps.
Yes, ma'am.
Exactly.
Thereafter, the procedure required to be followed under section 102. 4 conditions are to be fulfilled.
Yes.
If not, this order of
If it is
freezing will go.
my lord,
So get the instruction then from the officer in charge.
my lord.
If it is not in connection with any police, then bank has no authority.
Yes.
Exactly.
That information.
And if it is in connection with any police case,
Yes,
then some procedures
Have to follow.
are to be followed.
Yes.
And Mr. S.C. বিশ্বাস, Learned Counsel for the petitioner, and Miss. Then how do you serve this bank manager? We have to issue notice.
That is what I'm saying.
MSM Bormon, Learned Junior Government Advocate Assam for the respond number 1 to 4. Full stop. The petitioner who is maintaining a savings bank account bearing number Peratudas, which at Nagaon branch, at Union Bank of India, Nagaon branch, district Borpeta, with IFSC code, has been maintaining. On and from which date?
8/5/2023.
8/5/2023. The said bank account of the petitioner has been freezed by the respondent number 5 bank maintained with so and so for the bracket of respondent number 5 for it. On the purported on the ground of purported fraud reported by a complainant, purported fraud to the extent of 5,000 reported by a complainant from Annexer 3 to the petition. It appears that a complaint was lodged with Borpeta Police Station by one Ripon Kolita. Issue notice returnable on data.
For short date, my lord, because of
6. You waited from May now. As MS
6 months.
appeared, accepted. 1 to 5, 4, no formal notice.
By registered permit.
Petitioner shall take stage for service of notice. Upon the respondent of 5 by registered post utility. You want Dusty also?
Yes.
Dusty, take it over. In addition, Dusty, respondent of 5. Please the case on 6. MS Bormon,
Diploma.
Learned Junior Government Advocate Assam shall obtain instruction as to whether the bank account of the petitioner has been decreased in connection with any crime case, and if yes, the procedure followed for defreezing the account.
Number 13.
May I please? My lord, in this matter, my lord, the inclusion of the names of the private respondents, my lord, as a shareholder, my lord, they illegal, and as such, we filed a representation before the assistant registrar, my lord, for a scrutiny, my lord. But that representation was not disposed of, and there no scrutiny was made, my lord.
When the election?
Election is on 8th.
8. Today we are on what? 5th?
5th, my lord. My lord.
When did you file?
My representation filed was on October, my lord.
Huh?
In the month of October. First one is filed 9/10/2023. And then, my lord, it was filed on
9/10/2023.
9.
Now tell me, when the voter lists have been finalized?
It was only finalized on in this month, my lord. Or January, my lord. January 5th, January, my lord.
Where is the election notice?
Election notice, my lord, I have not annexed, my lord.
Huh?
Not annexed, my lord. Only, my lord, this representation, my lord. An inquiry may be conducted, my lord.
What inquiry? See, one who is sleeping.
My lord.
And
under the
wakes up just before the election date.
My lord.
We have to examine the situation. Tell
lord,
me.
We have filed.
Tell me on which dates you have filed the representation. Where is that representation?
My lord, at page, my lord. At page 27, my lord.
27.
Yes, my lord.
Where is the original copy?
My lord, next page, my lord, it is 29, my lord. It was received on 9/10. And register received on 19/10, my lord. This is the address to the secretary, my lord. 1 month committee, my lord. And then it was another representation, my lord. On 13/10, my lord, addressed to the Assistant Registrar of Cooperative Society, Dublin. We have specifically alleged that the
Mr. Uddin,
my lord.
what you have alleged specifically
Yes,
in paragraph 4 of this writ petition,
my lord. My lord, this is the allegation.
you have not alleged in page 29 representation.
My lord, in 37, my lord, it is 36, my lord. And in 37 is the vernacular, my lord. Specific allegation, my lord. That under the same registration number 188, 3 names are included, my lord. That cannot be, my lord.
The page 37, I have not understood. Please explain me. Comic number 725.
My lord, at page 60,
On page 37, because this page 29 is too vague.
my lord.
Page 29 representation is very general.
But my lord, 37.
Nobody will pick. You have to specifically identify. These are the names which are to be deleted. Now
Yes.
come to page 37.
Yes, my lord, 37.
It appears that it has been
188 session number.
for whom you have submitted.
It was submitted before the Assistant Registrar of Cooperative Society.
Does it so? Because it appears the register of cooperative society.
Lordship,
Seal.
section 87, your lord.
Huh?
Under section 87, his pair is for an inquiry. So the application should be filed before the register of the cooperative
Register
society.
received, my lord, on 1910, my lord.
And within 10 days, the registrar has to decide, your lordship, whether to conduct an inquiry or to
What is page 87?
of the act, your lordship, of the Cooperative Society Act 2007. Section 87, Your Lordship.
No, is it a federal or secondary cooperative society?
To which a cooperative society or of a creditor whom the cooperative is indebted.
Read subsection 1.
Yes.
Registers shall on the application of a federal or a secondary cooperative society
Lordship.
to which the cooperative society concerned is affiliated. There is no question of affiliation or of a creditor
Lordship.
to whom cooperative is indebted or of not less than 1/3 of the directors
Yes, next sentence, Your Lordship.
or of not less than 1/10 of the members. Hold an inquiry or cause an inquiry into any specific subject relating to any violation of any provisions of this act.
Or by law.
Okay.
And registrar shall order inquiry or reject the application for an inquiry showing the reasons within 10 days from the date of receipt of application. This representation was filed in the month of October. They had enough time to approach the registrar. Your Lordship.
Register received it on 1910, my lord.
How many, the society of consists of how many members? Shareholders.
My lord, total shareholder, my lord. I'm not aware, my lord. Total,
There is no statement.
no statement.
Because
regarding-
only allegation in page 37 in respect of 3 persons.
Yes, ma'am.
Your allegations are only 3 persons.
Under the same register number,
Maybe.
their
Mr.
name,
Raspa, only 3 persons, not that
Yes.
many hundred dead members.
Not.
Specific allegation. This assistant registrar of cooperative society, where is the election rules? Mr. Uddin,
my lord.
that election process which has been initiated,
My lord, I am not,
we do not want to.
no, I am not asking, my lord. I am not asking for stay, my lord. Just for an inquiry, my lord. By the assistant registrar or by the registrar, my lord.
But it is only on 8.
Today we are already on
We are on 5th.
private respondents are also there.
No, for the purpose, it appears that this society consists of many members from the.
Yes, ma'am.
Just having a look at page 15 or page 16, we can easily find out at least it consists of 990 members.
No, my lord, that page 25, 2,790.
2,700. Just because 3 names are there, why should we stall a democratic process?
No, we are not asking. my lord.
Issue notice. In the meantime, they may inquire.
Yes, ma'am.
They may take this application,
My lord.
page 37,
Lordship.
and dispose of it.
Yeah.
Pendency of the petition will not pay back. But we have 2,500 members.
Yes.
Just because 3 persons.
Yeah.
And you have not pursued the matter with due diligence. Since October,
My lord.
you are sleeping.
My lord.
We don't know. We don't know. All right, Mr. Keudin, counsel for the petition. Every petition challenging election to a cooperative society is filed just before the date of election.
No, my lord, it has not challenged the election. my lord.
And Mr. B. Raskwa,
Veera.
petitioners, B. Raskwa, Standing Council Corporation Department for respond number 1, 2,
1, 2,
3,
5.
4, 5, 6. Returning officer,
Yes.
he is also under register. Who are the private respondents? Those three.
Four, my lord. Another one is, my lord, Ahmed Hussain Chaudhry, my lord.
No.
Yes, my lord, those three, my lord. My lord,
In para four,
Abdul
they have
Hakim.
mentioned four.
The
under
petitioners.
representation.
Abdul Hakim.
3%, then Abdul Hakim.
Yes.
Okay.
Then, my lord, Abdul Hakim.
Sohidur Rahman.
Panbora.
Saidur
Okay.
Rahman, 8.
Sohidur Rahman. Abdul Hakim, Sohidur Rahman.
Panbor Ali we have not made, my lord. Panbor Ali not made. My lord, other two persons, my lord. This,
Who are they?
my lord, they are using, my lord, registration of another person, my lord. 11, my lord. And, my lord, 9 and 10, my lord, they also not completed 1 year of the.
The alleging inclusion, stroke, exclusion of the names of the private respondents hearing in the voters list of Messrs. Modhu Pol Mari Homobaya Homiti Limited, Gauripur, District Dhubri, a cooperative society registered under the provisions of the Assam Cooperative Society Act 2007. Comma, the petitioners, two petitioners who have claimed to be the shareholders of the said society, comma, have prepared the instant petition. The election of the board of directors of the society is scheduled on
8, my lord.
8
8
to 2024. Most of the petitioners have submitted that by a representation before dated 13/10/2023, before the respondent number 2 and the respondent number 4. The petitioners have brought the allegations against the private respondents, but the said authorities have not acted upon the said representation. Issue notice returnable in 4 weeks. As Mr. Raspa 1 to 6, the petitioner shall take steps for service of notice upon the respondent number 7 to 11 by registered post will be 80. Pendency, it is observed that pendency of the requisition shall not be allowed for the respondent authorities to consider the representation, comma, dated, comma, stated to have been submitted by the petition on 13/10/2023, comma, in accordance with.
Division Commissioner. Accordingly, notice was issued. And my grievance was that part of the building was demolished, but other part was not calculated or given compensation. However, my lord, for the remaining part, a joint survey was, direction was given to conduct a joint survey as per the order dated 2nd of February 2023 by the Upper Assam Division Commissioner, come arbitrator. However, the problem, my lord, occurred on 17th of July 2023 when the whole office was abolished. Now, as per my latest information, those all those cases relating to all Assam are before the Joint Secretary, Principal Secretary at Revenue. So neither the report has been provided to me, nor the case is proceeded further, nor the arbitrator has been appointed, for which I have been suffering, my lord.
I think.
Yes, one direction.
Yes, MS Bordoloi. In one case, I think
Yes, today I got the,
mandamus was issued
Yes, sir.
to the central government
Yes,
as well as state government
yes.
to appoint an arbitrator.
That notification I have furnished on last occasion, Your Lordship, Mr. Ashok Burman, retired IS officer, has been appointed as the
Do you
arbitrator.
have the notification?
Yes, I have already submitted to the
How?
court master.
Because in, I think, in a batch of writ petitions,
today I got one judgment at WPC 682823.
yes.
Yes. Two directions were given. First direction was that to appoint within a period of 1 month. And second direction was to dispose of those writ petitions, 4 or 5, I think, within a period of 1 month, 6 months. That order I have at my mobile. Today I downloaded it. My
Is there any subsequent notification by the central government?
No, Your Lordship.
Because
Yes.
state government has
Yes.
nominated a person.
Yes. After this.
Thereafter, the notification has to be
Yes.
issued under section 3Z5
Yes.
by the central government.
Yes.
Is there
Yes.
any
No.
notification
Lordship,
issued?
in a connected case, Your Lordship, by the Honorable Coordinate Bench of this Honorable Court. Your Lordship, this is order dated 22/1/2024, passed in IA Civil 2841/2023. Here, Your Lordship, this one, Mr. RKD Chaudhary, he was actually directed by the Honorable Court to apprise the
Yes, so it's
regarding-
Mr. RKD Chaudhary.
Lordship.
Because petitions are coming,
The steps taken. Under such circumstances, this court again fixes the matter on 12/2/2024, on which date Mr. RKD Chaudhary, learned Deputy Solicitor General of India, would apprise this court as to what further steps have been taken by the central government for appointment of arbitrator. In that regard, the central government may also
where is NHI DCL
make appropriate.
council? Have you served copies?
Yes.
Hmm?
Talukdar was there, Mr. Talukdar.
Where is Mr. Taludar? You can issue notice. Return will be in short period,
Yes, sir.
because we have already issued
Yes, this
similar direction.
this 1512 notification I've already furnished on last occasion, Your Lordship.
Yes, but
Yes.
it has not concluded
Yes.
till date.
Yes. The central government has to take the
As per
necessary
the,
steps.
as per the submission of the RKD Chaudhary, the name of Ashok Kumar Burman has been rejected. Because he is a retired person. Thereafter, no communication has been received by the department, revenue department, from the central government.
What is the WBC number where we have directed?
Yes. 6828/23.
6, 8,
28/23.
20.
This was passed on
Ulakshman.
8th of December 23. Almost 2 months. Whereas direct time period was given for 1 month.
Heard Mr.
DK Nath.
DK Nath, learned counsel for the petitioner. Any CDC?
Yes, sir. Okay, sir.
Names are not. CDC name is not there. MS and Borderline Standing Council. Revenue Department for respondent number 2. MS S. Sharma, Learned Junior Government Bukit Assam for respondent number 3, 4. Full stop. The case of the petitioner is that initially the request of the petitioner seeking enhancement of the compensation, seeking
Yes, enhancement and
enhancement,
recalculation.
stroke
Recalculation of the other remaining
Recalculation.
portion.
of the compensation amount was considered by the arbitrator appointed under section 3Z within bracket 5 of the National Highways Act 1956. And after consideration, the arbitrator so appointed, by an order dated 2/2/2023.
My lord, last paragraph, third line, 69 page.
Had inter alia directed to make a joint field verification.
Yeah.
And to find out whether compensation can be given in respect of the unused portion of the dismantled building demolished during the acquisition process. Full stop. The competent authority, land acquisition, was directed to verify the matter in the light of the provisions contained in section 3G7 of the National Highways Act 1956 and to submit report accordingly. Full stop.
Now this, that
It is the
conduct,
case of the petitioner that subsequent to the Commissioner, Upper Assam Division, Jorhat, was the arbitrator appointed by the central government under 3G5 of the National Highways Act. Full stop. It is the case of the petitioner that subsequently the office of the Upper Assam Commissioner, Upper Assam Division,
divisional commissioner.
Upper Assam Division, Commissioner, Upper Assam Division, was abolished by notification dated 77/2023 of the General Administration Department, Government of Assam. Full stop. In view of such abolition, the petitioner has contended that in view of such abolition of the office of the Commissioner, Upper Assam Division, there is no arbitrator presently appointed under 3G5 of the NH Act 1956 Act to consider the case of the petition. Full stop. The petitioner has approached this court by the instant petition, seeking inter alia direction to the respondent authorities to appoint an arbitrator under 3G5 of the 1956 Act for the purpose of disposing arbitration case number 25/2022. Full stop. Issue notice to the respondents returnable on short time.
Well,
MS Borderler,
Yes, Your Honor.
because other respondents can be represented 19 to 2024 as MS Borderler has appeared and accepted for 2, S Sharma 3 and 4, no formal notice, extra copies within by tomorrow. The learned counsel for the petitioners will also serve copy of the writ petition along with annexer to Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India for the respondent number 1, and Mr. R.K. Talukdar, learned Standing Counsel, National Highway Infrastructure Development Corporation Limited, NHIDCL, for the respondent number 5 and 6 by tomorrow. Please, the case. On. Rising.
Item 16.
In this case, my lord, as already, my lord, in similar matter has been already passed before your lordship. In this case, actually, what is happened, my lord? Petitioner-
Bilasibara,
No, no, Abhaipuri, my lord.
Obhayapuri.
Abhaipuri. In this case, pursuant to the letter of the government, my lord, Annexure 1, page 19. The
Issue notice at this stage.
Yes, yes, my lord.
Third, Mr. H. Das. Learned counsel for the petitioner. G. Hazarika, standing counsel revenue 1, 2, 3, 7. MS S. Sharma, learned junior government advocate Assam for the respondent number 3 to 7. The case of the petitioner is that after allotment of a plot of land measuring 1 katha 10 lessa situated at village of Ayapur, Srijangam revenue circle of Ayapur, district line, comma, his name was mutated in respect of the said plot of land on 6/11/1998. But in view of a communication dated 16/7/1999 of the Commissioner to the Government of Assam Revenue Department, comma, the name of the petitioner stood deleted from the said plot of land and the status of the said land, plot of land stood changed to government caste land without any notice to the petitioner. The petitioner has stated that the said communication dated 16/7/1999 has been set aside in a set aside by an order dated or in a connected with proceedings. Full stop. The present petition has been filed seeking restoration of the petitioner's name as patta holder in respect of the said plot of land measuring 1 katha 10 lessa. Returnable for it as so appeared, accepted, no formal notice. Extra copies by tomorrow.
Oh, let's.
Item 17.
Here in this case, my lord, I have challenged the arbitration proceeding, my lord, initiated by the respondent number 1 and 2, my lord. Without, my lord, taking any consent, the respondent number 2, my lord, appointed the respondent number 2 as arbitrator. In this case, my lord, what happened, my lord? The petitioners, my lord, they, my lord, got a contract, and in the said work, my lord, the respondent number 1, my lord, he participated, my lord, he, my lord, invested some amount. Then after, my lord, completion of the work, his share was given. He was not satisfied. He filed a FIR.
How Mr. Ali lost the petition is made.
This, my lord, under 227, my lord, we have filed this petition, my lord. Because our
You need
appointment
not
of
have to proceed further. This has to be closed today.
arbitrate appointment itself, my lord, is against the, my lord. Act, my lord. The respondent number two him was appointed by the respondent number one. Then I filed a title suit, my lord, before the landed trial court, civil court, my lord, challenging the validity of the agreement. Suit is
See,
pending.
that is a self-contained, that is a separate act, law. 1996 act. If after conclusion of proceeding, section 34, 37, all are there. And if some orders passed during the arbitration proceeding, that can be also challenged in section 34. And time and again, Supreme Court has said this kind of petition, writ petition is not maintainable. I tend to not.
His petition has been filed, my lord, under, my lord, Arbitration and Conciliation Act, my lord. So appointment of arbitrator, my lord, also should have been, my lord, under section 11. Now he himself, my lord, appointed. And I have filed petition.
This has to be challenged in other manner, not in this manner. This has to be challenged in some other manner. Is it not? A mobile phone. I think there is a judgment, Deep Industries. Deep Industries. Mr. Ali, Lordship, this is not the forum.
But in Parkins, my lord.
Parkinson is different thing.
Sole arbitrator, my lord, cannot be by.
That is section 11, Mr. iPad to keep mobile phone. Is not working. Parkinson is different thing. Section 11. You are in 226.
I filed this, my lord, 227, my lord.
227 also. Same thing. Hey, Deep Industries, not Deep Industries. Okay. 2020, 15 SSC 705. Two thousand 15 SSC 706.
by Honorable Justice Nariman. I'll go, my lord, through it, my lord.
You don't have to go. It is settled. Subsequently also, another three judgments. Nobo Yuga. Nobo Yuga. And secondly, fundamental error is that who are the respondents? Who are the respondents?
The arbitrator and my lord,
The other contractor.
lordship. Who appointed the arbitrator?
All these questions can be raised in the final order to be passed. All these issues have been answered. I say. Order. Oh, Yuga. CC 9 SC Novoyoga ने की बता यार नेट तो ठीक कर बोले वो नेट से नहीं arbitration conciliation account. If you want, only I can keep it up to Wednesday only.
Lordship.
Otherwise, you will tell me that I have violated the principles of natural justice. Two 226, 227, both have been dealt with. Regarding your specific submission, under section 34, the aggrieved party has an avenue for ventilating its grievances against the awards, including any order in between orders that might have been passed by the arbitral tribunal acting under section 16. The party aggrieved by any order of the arbitral tribunal, unless has a right of appeal under section so-and-so, has to wait until the award is passed by the tribunal. This appears to be the scheme of the government act. And disapprove the stand adopted by some of the high courts that any order passed by the arbitral tribunal is capable of being corrected by the High Court under Article 226, 227 of the Constitution. Such an intervention by the High Court is not permissible. Am I clear? We'll close this. I heard Mr. R. Ali, Learned Counsel for the petitioner. Full stop. The petitioner in this petition preferred under Article 27 of the Constitution of India has assailed an arbitration proceeding being arbitration number 01/2020 initiated on the basis of an agreement purportedly executed on 28/2/2019. So it is the case of the petitioner that the respondent number 2 has been appointed as an arbitrator by the respondent number 1. Full stop. Apart, other than the respondent number 1 and the respondent number 2, there is no other respondents in a Senate petition. Full stop. In this writ petition, the petitioner has been setting aside and quashing of the arbitration proceedings initiated by arbitration case number 01/2020 presently pending before the respondent number 2. Full stop. An interim order for suspending the operation of staying the further proceedings of arbitration case number 01/2020 has also been sought. Full stop. It is settled by the Honorable Supreme Court of India in Deep Industries Limited versus Oil and Natural Gas Corporation Limited and under reported in 2020 15 SSC 706. That any order passed by the arbitral tribunal is not capable of being corrected by the High Court under Article 226 or 227 of the Constitution of India. Full stop. The object of an arbitration proceeding is to minimize judicial intervention while the matter is in the process of being arbitrated upon. It has been held that the purpose will be defeated if the High Court could be approached under Article 227 or under Article 226 of the Constitution against any order made by an arbitral tribunal. Full stop. It has been held that once the arbitration has commenced in the arbitral tribunal, parties have to wait until the award is pronounced. Unless, of course, a right of appeal is available to them, unless, a right of appeal is available to them under Article 37 of the Arbitration and Conciliation Act 1996, even at an earlier stage. In view of the above position of law, the writ petition is not answered. In Novoga Engineering Company versus Bangalore Metro Rail Corporation, reported in 2021 SSC Online SC 469. Following the decision in Deep Industries Limited, Supra. It has been observed that the High Court, while exercising power of judicial powers, exercising jurisdiction under Article 226 or 227, should be extremely circumspect in interpreting with orders passed under Arbitration and Conciliation Act 1996, and such interference being only in cases of exceptional rarity or cases which are stated to be patently lacking in inherent jurisdiction. Absolutely not in fact.
I don't know what I feel.
Yes.
This case, your lordship, this case is regarding conversion of annual patta to the periodic patta. So the petitioners have filed application in the year 2013, and there are some reports. The reports is given by the mandal to the circle officer. Circle officer again passed an order confirming that report and send it to the deputy commissioner. But after that, nothing has happened, your lordship.
Annual patta to periodic patta.
Periodic patta. And
it is under some provisions of law.
Yes.
Settlement rules.
Settlement rules.
Yes, madam. Under what provision? Conversion of annual patta to periodic patta.
And,
Yes,
and
Mr. Upadhyay, under what? Under what rule?
And the report is there, your lordship.
Report is there. What is the provision? Statutory provision.
One is 105 section, your lordship.
105.
Yes.
Of the regulation?
Yes, land revenue regulation.
No, that is partition.
105 is partition. Under that section, a notice has been issued to us, your lordship. Because there are several persons entitled to get this land.
What is your case?
My case is
Partition or conversion?
Conversion, your lordship.
Yes, madam. Yes, Mr. Upadhyay. What is the provision? Niyadi case. So it is basically for the purpose of conversion.
Conversion.
You prefer this application, please come to Annexer 8, page
Annex
39.
A.
Page 39.
Yes, your lord.
Application has been submitted successfully. Okay. Was in 18 January 2023. What happened thereafter?
18 January 2018.
2013, you have
Yes,
submitted.
The mandal has prepared the report, your lordship. Annex 2. He has reported it to the circle officer. Page 21, your lordship.
2014, what happened after this, page 39?
And after that, your lordship, the circle officer has passed the order.
Today, seeking Miyadi Patta plot land. 1 bigha, 4 katha.
1 bigha 4 katha. And the premium is also fixed 1,35,000, your lordship.
What is page annexer 10, page 45?
Page 45. Yes, your lordship. This is regarding if any objection is there. Notice has been issued, your lordship. To all the family members, they are all the family members of this same family, your lordship. As the great grandfather is the same, your lordship. Because of that,
What is your application object for application?
just to consider my case as early possible, your lordship. Because I am waiting from 2013. We are waiting from 2013.
What is your application?
2013 application.
Your application is pending?
Yeah.
Is part of this petition?
Is part of this petition.
Who is that?
Annexure 1, your lordship. Page 18.
Heard, Mr. NN Upadhyay. Council for the petition. And Bodulu. Standing Council Revenue.
1 and 2.
1 and 2. MSS Sharma. Junior Government Advocate Assam for the respondent number 3 and 4. Full stop. The two petitioners have claimed that they are legal heirs of one late Sunti Hazarika and are in occupation of a plot of land, measuring 1 biga 4 katha, covered by tag number 216 and annual pattern number 17, situated revenue village, Zengkotia, Moja, Nagar Mohal, Ipsagar, Assam, subject one. The prior case of the petitioner is that on 29/7/2023, the petitioner had submitted an application seeking conversion of the subject lot. Conversion of status of the subject lot from annual patta land to periodic patta land. The grievance of the petitioner is that, on the basis of the said application, a case, Miyadi case number 23/13-14 has been registered. The grievance of the petitioner is that though proceedings have been initiated, but as far back as in the year 2013/2014, for the purpose of conversion of the subject, for the purpose of conversion of the status of the subject plot from annual patta land to periodic patta land, the proceedings have not been concluded till date, despite elapse of about 10 years. Full stop. Aggrieved by non-conclusion of proceedings of Miyadi case number 23/2013-14, the petitioners are before this court. Issue notice returnable in 4 weeks at Bodule, Sharma. Accepted notice, no formalities, extra copies within 2 working days. 13.
Rule 30, man.
I know.
Item 19.
Learned State Council. On the next date of listing, commercial produce rule 13. Shall produce. The instructions issued by the state government as regards conversion of annual lease into periodic liens. Yes.
I appear for the petition 19. Lordship, here I was audited by the state GST department, and after the completion of audit, the final discrepancy notice was issued to me, to which I gave a reply. And the only issue which was raised was regarding one of my vendor, supplier, from whom I have taken services. He has not shown certain invoices in his return. To that reply, what I had given, that all my bank payments, all invoice copies, all challans, that the tax I have already paid to him. And there are 2 press releases by the Ministry of Finance stating that if anything is not appearing in 2A, first action has to be taken against the supplier if the supplier has not paid the tax. We gave a detailed reply. After our reply, they issued us a final audit report in 2 lines stating this reply is not acceptable. And Lordship, after that final audit report was issued on 8th of January 2024, within 3 days, they issued us a show cause notice. Lordship, it's a settled jurisprudence now. Various courts under the GST regime, I have relied upon certain judgments also, Lordships, when it has been stated that if first the recovery action, if it is proved through documents that the tax has been paid by the recipient to the supplier, and for any reason whatsoever, the supplier has not paid the tax, the first action has to be taken against the supplier. And if suppose this is a transaction of collusion, wherein the supplier and the recipients have colluded and defrauded the government, then action can be taken against the recipient. This is what the GST law has also stated clearly in the instructions issued by the department. To that extent, my only humble reply before the audit officer was also same. I provided the bank statement copies, my ledger copies, invoices copies, everything. More so, Lordships, that person, that supplier is still active today in the GST. I have given a screenshot also that this GST number is still active and is still doing business. What he has done in the between first 3 years, he was running a GST number in the same pen.
Right, Mr. Kanodia. We are at the stage of issuance of show cause notice normally.
Lordships.
Right. What is the harm in giving a reply?
Already given, but not considered. Kindly comes, Lordship.
Just show cause notice.
Lordship, prior the initiation of show cause was a discrepancy note. That is copied in the show cause. I'll take you to your Lordship to the documents. And we gave a detailed reply, including all the invoices, bank statements, supplier payments, proof, everything. They have not considered at all and they issue a show cause. Lordship, now replying to this show cause will be an empty formality again. Because already my reply is on record, which has not been considered before issuance of show cause. And the adjudication is to be done by the same officer. Lordship, I wish to participate had my replies been considered. The only concern was that the supplier, LS supplier, is still active, is still doing business. 18 lakh of rupees I have already paid to him and no action against him. He's free to do business and I am being penalized twice. Once I have already paid the tax to him and now a notice has been issued to me for recovery of the same tax along with interest and penalty.
To show cause as to why.
Lordship, I go down to your Lordships, but Lordship, that the initiation of that show cause.
Normal procedure is at the stage of show cause notice. Normal.
Lordship, I go down to your
jurisdiction.
I go down to your Lordship.
Normally, when everything is in place, regime is in place to reply to the show cause notice.
Lordship kindly considers my 2 documents. If your Lordship then relegates me, I have no option, I will Lordship. But kindly comes to your Lordship, the audit memo I placed.
Otherwise, if we go on
Lordship, it's
power at the stage of
Lordship, I'll take
show cause notice, then Numbers will end up, Mr. Kanodia.
So I'll take you to two judgments of Division Bench of the Calcutta High Court, which has been affirmed by Supreme Court on 14th of December. At the same stage, Lordship. Though leave was not granted in that matter, but under the facts and circumstances, the SLP of the revenue was dismissed.
Yes, Mr. Chaudhary. Have you received a copy of your petition or not?
Yeah, yes, my lord.
Where is your show cause?
Lordship, the show cause notice is at page 43. The page 43 is the form, Lordships. Page 46, the show cause is there.
Under section 73.
Lordships. Lordships, can I take you to the audit first, Lordship, the memo, which was the genesis?
We'll go.
Grateful.
Now come to page 46.
Lordships.
Now they have referred to some clause 4.1.1 and clause 4.1.2 in their show cause notice. I think this is the show cause notice.
Lordship, this is a show.
And there they have mentioned that certain things which were required to be done were not done. Because he speaks about some certificate, say clause 4.4.1,
Lordships.
in case where difference between the ITC claim in form GSTR 3B and that available in form GSTR 2A of the registered person in respect of a supplier. Your supplier is perhaps Atikur Rahman.
Lordships.
Supplier for the said financial year exceeds 5 lakh. Your case is exceeding
Exceeding 5 lakh.
5 lakh. The proper officer shall ask the registered person, means you,
Lordships.
to produce a certificate from the concerned supplier, from the certified accountant or the cost accountant certifying that supplies in respect of the said invoices of supplier have actually been made by the supplier to the said registered person, means you.
Lordship.
And the tax on such supplies has been paid by the said supplier in his return in form GST or 3B. Certificate issued by CA or CMA shall contain so and so. UDIN of the certificate issued by the CAs can be verified from so and so, and that issued by the CMA can be verified from so and so. Clause 4.1.2 provides that in cases where difference between the ITC claim in form number so and so and that available in so and so in respect of supplier for the said financial year is up to. So basically 4.1.1.
Now, Lordship, I will place before your Lordship why that cannot be applicable in the facts of the case.
Facts we are not going.
No, not on the facts. Why, Lordship? I'll kindly comes to the reply, Lordship. Then the discrepancy. I'll take your Lordship to that.
Then you have submitted or enclosed the invoices raised by Atikur Rahman which are not reflecting in GSTR 2A of the RTP. But in absence of reflection the name in GSTR 2A, you have not submitted the certificate from the concerned supplier. The effect the said supplies have actually been made by him, which is not required as per the said circular for availment of such ITC. Now, they are bound by the circulars.
But that is not applicable in my case, Lordship. I'll show to your Lordships. The sequence of events I'll show to your Lordships. And I rely on 3 High Court judgments, Lordship, on the same facts of the case, exact facts.
We'll see.
Grateful to them.
Yes.
Lordship, may I place the audit memo? That is at page 36, Lordships.
Yes.
Lordship, it says, in course of conducting the audit of accounts and records of Surya business, having principal placed this for the period 18-19, the following irregularities, discrepancies have been noticed, and the same is informed in terms of Rule 101. Then, Lordship, the same extract which your Lordship has seen in the show cause, the exact same table is extracted. And Lordship, page 37, it says, as such, the auditee has to reverse ITC of rupees this much as per the provisions of Assam GST Act and Central GST Act. Now, Lordships, here, which provision? They have not referred to any of the provisions. Again, Lordship, I'll take you to the table. Table says, during analysis of ITC of the auditee, it has come to the notice that the auditee has claimed.
Where you are reading from? Which
Lordships,
table?
page 36, Lordships. Above the table, observation 1, Lordships. Input tax credit claimed in excess. My Lordships are there. During analysis of ITC of the auditee, it has come to the notice that auditee has claimed excess ITC amounting to this. The details of ITC available and claim is mentioned as per below. Then, Lordship, there is a table. After the table, Lordships, they say, as such, the auditee has to reverse the ITC of this much as per the provisions of Act. Lordship, if I have availed in ineligible ITC, then section 16 of the Act deals with the provisions of availment of input tax credit. Which provision they say they are very silent. Till that time, I am also okay, Lordship. Then I reply to this. My reply starts at page 38. They just say basis the difference in GSTR 2A and GSTR 3B. You have to pay this amount. Page 38, Lordship, my reply starts. Lordship, I'll take you to the relevant page, page 39. After the table, where is the, what I have written? Lordship, page 39. Page 39, Lordship, I am reading after the table. The auditee states that the above difference in CGST and SGST head pertains to inward supplies received from one of its supplier, Mrs. Rahman, GST number this, for the business premise taken on rent by the auditee. However, these invoices are not reflecting in 2A of the auditee. The auditee states that ITC on invoices raised by Mrs. Atikur Rahman has been availed based on valid tax invoices, and the auditee has made payments of tax and rental charges to the supplier, which can be duly verified from the ledgers and bank statement of the auditee. I have attached all the invoices, ledgers.
You're referring auditee as yourself.
Myself, lordships, myself. Lordships. Heavy lordships.
Yes.
Lordships. The auditee states that the Honorable Supreme Court, Lordship, those annexures I have attached.
From your reading auditee.
Lordships, after that paragraph, copy of the invoices. That annexure, Lordships, kindly comes to page 49. Shall I take you to the annexures now, Lordship? Lordship, page 49 to page 82 are my invoice copies, ledger copies, and the bank statement. Lordship, I read after that. The auditee states that it has availed ITC based on the valid tax invoices raised by the supplier and also made the payment of tax to the supplier. Therefore, the auditee has correctly availed the ITC on such supplies as envisaged by section 59 of the Act. Section 59 of the Act deals with self-assessment. It says you have to avail input tax credit and pay output tax on self-assessment. Next paragraph, Lordships. The auditee states that the Honorable Supreme Court of India in case of Union of India versus Bharti Airtel and others reported in this, wherein it was observed by the Apex Court that a registered person is under an legal obligation to maintain its books of accounts and records, and that the registered person is obliged to do self-assessment of ITC and further compute its eligible ITC and output tax liability. It was held that the books of accounts maintained by the SSC are the primary documents and source material on the basis of which self-assessment is done by the registered person, including its eligibility and entitlement to get ITC, and Form GSTR 2A is only a facilitator for taking of an informed decision while doing an assessment. The relevant extract of the judgment is also attached with the appeal, with the writ petition, Lordships. Then, Lordships, further, while press release dated 18/10/2018 issued by CBIC, it was clarified that furnishing of outward details in Form 1 by the corresponding supplier and the facility to view the same in GSTR 2A by the recipient, your petition in the case is in the nature of taxpayer facilitation and does not impact the ability of the taxpayer to avail ITC on self-assessment basis in consonance with provisions of Section 16 of the Act. This press release is also a part of the pleading section. Next, Lordship, next further, press release dated 4/5/18 issued by the CBIC clarified that there shall be no automatic reversal of credit from the buyer on non-payment of tax by the seller. It was stated that in case of default of payment of tax by the seller, recovery shall be made from the seller and the reversal of credit from the buyer shall be allowable to the revenue to address exceptional situations like missing dealer, closure of business by supplier, or supplier not having adequate asset. This press release is also a part, Lordships. Then, Lordship, this press release, the first press release, 18/10/2018 is at page 104. And the second press release, 4/5/18 is at page 106. Lordship, the judgment of the Bharti Airtel is at page 83. The relevant paragraph is at page 102, para 46.
Yes.
Lordships. Lordship, then I say the auditee, after annexure A by full Lordship, I am reading. The auditee states that the supplier, Messrs. Atikur Rahman, bearing PAN number this, is still registered with the Assam GST authorities, while GST number this, whose status is active on the portal. Thus, it is not the case of missing dealer, and recovery, if any, should be made from the supplier and not from the auditee. The authenticity of the above can be independently verified by the department from common portal. Now, Lordship, here I have attached 2 screenshots also of the common portal. The same person with the pen was doing a business. He got one GST number. Then in November 2019, he cancelled that and obtained a new registration, which is still active today. Those screenshots, Lordship, are at page number 110. 108 to 110. Lordships. Lordship, may I please the next one? In the given facts of the Lordship, then I say that I skip that paragraph. That is the statement, Lordship. The auditee further relies on the judgment of the Honorable Calcutta High Court in the case of Suncraft Energy versus Assistant Commissioner State Tax charge reported in this and this, wherein the court held that recovery action against the defaulting supplier is essential before recovering ITC from the recipient, and the demand order as well as the show cause notice was set aside. The relevant extract of the judgment is given below. The first respondent, without resorting to any action against the fourth respondent, in that case, Lordship, the first respondent was the department, the fourth was the Atikur Rahman, in our case. In that case, the performer respondent, who is the selling dealer, has ignored the tax invoices produced by the appellant, as well as the bank statement to substantiate that they have paid the price for the goods and services rendered, as well as the tax payable thereon. The action of the first respondent have to be branded as arbitrary. Therefore, before directing the appellant to reverse the input tax credit and remit the same to the government, the first respondent ought to have taken action against the fourth respondent, the selling dealer, and unless and until the first respondent is able to bring out the exceptional case where there has been collusion between the appellant and the fourth respondent, or where the fourth respondent is missing, or the fourth respondent has closed down his business, or the fourth respondent does not have any assets, and such other contingencies, straight away the first respondent was not justified in directing the appellant to reverse the ITC availed by them. Therefore, we are of the view that the demand raised on the appellant dated this is not sustainable. In the result, the appeal is allowed, the orders passed in the writ petition is set aside, and the order dated this passed by the respondent is set aside. This was the judgment, Lordship, and this judgment was carried by the revenue to the Supreme Court. Supreme Court on 14 December, Lordships, there was no leave granted, but in the facts and the circumstances of the case, the SLP was dismissed. So, Lordship,
Calcutta High Court judgment.
Calcutta High Court.
Page.
Lordship, that is at page number 112. The Supreme Court is at page 1. The relevant paragraph is para 9, page 116.
So what is the report thereafter?
Lordship, now comes to the audit report, Lordship, which is at page 42. Audit report under 65(6). Your books of accounts and records of 1819 has been examined, and observations made during the course of audit was shared with you by reference number dated this. In your reply dated 1712, you have stated that there is a mismatch due to discrepancy in carry forward of ITC from 1718 to 1819. However, considering the returns filed by you, the same is not sustainable. Further, you have mentioned the availment of ITC from one Atikur Rahman bearing number this, which has not been reflected in 2A. Yet you have availed the ITC for the same. The issue has been examined in light of the provisions of the Act, as well as the Circular 183, dated 2712, and the availment of such ITC is not found as per law. Finished. Lordship, all my detailed submissions, starting from the press release, the judgment of the Supreme Court in Bharti Airtel, the judgment of the Honorable High Court at Calcutta, and other judgments also, Lordships. They say, and they, Lordship, kindly appreciates that no provision of the law, under which provision of the law they say that this ITC is not eligible to me. In fact, Lordships, for your Lordship's information, section 16(2)AA was introduced from 1st January 22. When this provision actually became mandate, that unless an ITC is reflected in my 2A, you will not get the credit. That amendment was introduced by Lordship section 16(2)AA with effect from 1st January 22. Prior to that, Lordship, there is no case of the department that there is a mismatch of 2A, 3B, you can avail, you can recover ITC. This is how they have dealt with my detailed reply to the audit notice, Lordships. And 3 days after that, they issue me a show cause.
What is ADT2?
AD2 is this final audit report, Lordship, at page number 42. Under section 65(6).
No, come to page 39.
39, Lordship.
What is the after the table?
Lordships. The auditee states that there's a difference.
However, their point is that, however, these invoices are not reflecting in ZTR 2A.
Correct, Lordship.
What is this?
Lordships. So, Lordships, in GST regime, there is a return filing by the supplier and by the recipient. Every person who issues, supplies goods or services has to file a return in GSTR 1. And that gets reflected in the recipient's portal, in the common portal, in the form GSTR 2A. It's a viewing form. You cannot edit it, Lordship. One cannot edit it. So, if my supplier has supplied me goods or services, he has to report in GSTR 1, which is auto-populated in my 2A. Now, Lordship, what that 183 circular which the department has referred, that circular was issued to cover up situations. Suppose my supplier has made an inadvertent mistake. Instead of GSTN of mine, he has reported GSTN of Mr. B. So to cover up those mistakes, circular 183 was there in the law. But I am not on that point, Lordships. Our point is, when from records it is established that there is a receipt of goods, services, payment has been made, everything has been complied, the press release of the CBIC is being complied. How can department ask me to reverse ITC? Under which relevant provision of the law? Neither their show cause raises any section, you have violated this section, neither their audit discrepancy note, neither their audit report. An audit report, Lordship, has not dealt with my reply at all. Lordship, I would like to place this press releases before your Lordships. And my period is covered by that, Lordship, 1890. Bharti et al. Also, Lordships, that was the exact point laid by the Honorable Supreme Court that 2A is a facilitator. You can view, but ITC is to be taken on self-assessment on books of account. That is what we have done, Lordships.
There are other steps also. GSTR 2A may be a facilitator.
Lordships.
Right. But when an audit proceeding is initiated.
Lordships.
Right.
Lordships. Lordship, their demand is on the ground. It is not coming in 2A, you reverse. Where is that law, Lordships? I'll take you to section 16 to AA. It was introduced from 1st January 22, Lordships. And we are covering it, and it's not a retrospective amendment.
No, then suppose something is missing in GSTR 2A.
Lordships.
Right. There are subsequent steps, it appears.
No, Lordship. If I have taken ITC on self-assessment, when an audit comes,
What is GSTR 3B?
3B is the payment return. After ITC, GSTR 1 is output return, 3B is the payment return. Total output less input. The net amount which GST I have to pay. I have to file GSTR 3B. It is a summary return, Lordship. For example, may I give an example, Lordship? Say during the month of January, my total outward sales was 1,000 rupees. In that, the GST amount was 100 rupees. I have to pay 100 rupees to the government. The due date is next month 20th. And my purchases were 80 rupees, on which GST was, purchase was 800 rupees, GST was 80 rupees. So in GSTR 3B, I have to show output 100, input 80, payment 20. That payment is made through 3B. That is a payment return, Lordship. That is, Lordship, our case is when the department press release itself states that two things, that 2A, no demand can be raised basis 2A. And second, if at all you see that the supplier is not paid, the recovery is to be first made from the supplier, not from me directly.
There is page 47.
Lordships.
They have said something
That's
like a step from your side also. That
Lordship, I am not bound by that circular. Your lordship said very correctly. I go down to that lordship. Your lordship before rising had stated.
Sir, we are not in appeal, Mr. Kamadia.
Lordship, we are not in appeal.
We are not in appeal.
We are not in appeal.
First thing you have to remember.
Lordship, we are
to
not in
make
appeal.
submission.
Lordships. We are not in appeal.
We are in 226 only.
Lordship, I go down.
At the stage of so-called notice.
Lordship.
And law is also settled to that extent. We need not have to advert to that.
I go down to your lordship.
Right. What is this circular then? 27/12/2022.
This circular takes into care 4 situations that if the supplier has inadvertently filed his GSTR1 in some other GST number, or he has missed to report any invoice, but he has made the payment of taxes to the government, then the recipient is asked if you get hold of the supplier, and if that supplier, you give a certificate from that supplier. But lordship, that is a obligation which the government is to do. I cannot do that. Today, that supplier is active. In situations where that supplier, that GST number is not active, where do I catch the supplier, lordships?
No, it asks for a certificate.
Certificate from the supplier.
Read.
Lordships, I place clause
Proper
4.
officer
Clause-
will ask the registered person, means you,
Lordship, me.
to produce a certificate for the concerned supplier from the chartered accountant or the cost accountant, certifying that supplies in respect of the said invoices of supplier have actually been made by the supplier to the said registered person. Now, from whose chartered account?
Lordship, my chartered accountant, can he give my supplier certificate that he has paid the tax?
No, no.
Lordship, I'll place that paragraph again, lordships.
So
Kindly-
ask the registered person
The prop
to
to-
produce a certificate from the concerned supplier,
for the concerned supplier,
for the concerned supplier.
from the chartered accountant or the cost accountant, certifying
That
supplies in respect of the invoices of supplier
said invoices of the supplier, said invoices of the supplier have actually been made by the supplier to the registered person, and the tax on such supplies has been paid
to the government.
by the said supplier in his return form.
Lordship, so in this point, how can my chartered accountant certify my supplier's return? It has to be suppliers. Otherwise, this would become inspector's, lordship. And lordship, the question is, how can this act all come into picture when the supplier is still active?
Yes, who is for the, yes.
Lordship may kindly turn over to page 46. The so-cause notice was issued on 11th of January 2024. And in page 48, Lordship, he has been given 30 days time. And that is yet to expire. First of all, he ought to have given his reply. Then only because the so-cause reflects that, taking into account the audit observation and the reply given to that audit observation, the following discrepancies were found. That is reflected in page 47, the last paragraph. My humble prayer at this stage that Lordship may not entertain it. He should give his reply to the so-cause, because it is still at the initial stage, Lordship.
What about this Supreme Court judgment?
Lordship, that will be taken into account by the authority while deciding the reply to this 11 January so-cause notice, Lordship.
The ground taken here is that in your reply to that page 47, your reliance in on clause 4.1.1
Yes, my lord.
It appears to be there should be a step in case where difference between the ITC claimed in Form GST or TB and that availing in Form GST or TB of the registered person in respect of a supplier for the said financial year exceeds 5 lakh.
Yeah.
The proper officer shall ask
A registered person to produce a certificate for the concerned supplier.
where is that circular?
That circular is not a part of this petition.
Hmm.
That is not a part of this petition. Lordship. It was neither a part of the show cause annexure also.
Everything is not required to be part of the show cause,
Lord-
Mr.
Lordship,
Kanodia.
because I was not relying,
You are not relying.
Lordship, I will
But they have,
place,
they have relied,
they have extracted that, Lordship.
departmental circular.
Lordship.
maybe, They have relied upon.
Lordship, but at the stage of stow call, Lordship, my audit, reply to my audit has then been dealt with, Lordships.
Mr. Kanodia, we are in the stage of show cause notice only.
Lordship,
We are
I am-
not into an
Lordship,
order.
prior to show cause, the basic facts that the contentions which were raised has not been dealt at all, Lordships. I will place, Lordship, the judgment of the division bench of Calcutta High Court in Sancraft, Lordships. Can I place that judgment for your Lordships? And similarly has been followed by the Madras High Court and the Kerala High Court, Lordships.
Whether that kind of issue has been raised
Exactly, Lordships. I'll take you to.
in this particular circular. Which
Lordship,
circular is this?
Lordship, this circular.
CBIC.
CBIC. Same circular with the state. It is same, Lordship, parliamentary. But Lordships, the main point of contention is whether any difference, can only a difference raise a demand of GST when without taking an action of the supplier. I am on only that humble point, Lordships, which we have addressed also. We have all the documents also, Lordship. Kindly take, Lordship, the judgment, Lordships.
We'll examine further, Mr. Kanodia.
Lordships.
Get that circular if you have that. Because we are examining a show cause notice.
Lordship,
not
I will,
any order.
Lordship, I am,
Otherwise, there are other judgments also.
Lordships, Lordships. But Lordships, I am not
You
on this.
cannot be oblivious of that.
Lordship, my only humble
Situation
prayer
also.
in the writ petition is that before demanding me at any demand, all the documents are with the department. That person is active today. He is doing business. As per the procedure prescribed by the law, the recovery has to be first made by him.
We'll
Lordship,
examine that judgment, Bharti Airtel.
Lordship.
There are other.
Lordships, I will place that circular on the whenever.
Matter. We'll fix the matter.
Lordships.
When you are, it is convenient for you. We'll fix the matter.
Lordship,
We'll examine. But
Lordship, the first matter in the morning you have fixed on 26th. If convenient to your Lordships, otherwise any short date as per your Lordships.
no, we'll hear on some other date. Not on 20.
Lord-
When you are, it is compatible. 27?
No, 27, no, Lord, 27 is Supreme Court, Lordship. That is why 27, 28, I told Lordships are not there.
Oh. Because when many matters are listed, it is difficult to examine.
Lordship, I would.
Because others are there.
I would on Lordships.
That is why I proposed 27. So otherwise,
Lordship can put
when?
it 20.
22?
Fine, Lordship. I'll be there.
22?
Yes,
Mr.
yes.
22 is a Thursday. Fine, Lordships. Lordship, that time because the due date to file reply is 12th. Till that time, my protection may be given to.
Lordship, no coercive action.
No, shall not act upon the so called notice.
Lordship.
Till the next.
Lordship.
I heard Mr. A. Kanodia, learned counsel for the petition, and Mr. Only if we find that we should cross this stage, then only we'll cross this.
Lordships.
Otherwise, we will not cross this stage.
Lordships. In my starting, I made a submission to your Lordship that
Mr. B. Choduri, learned standing counsel, finance and taxation department for all the, for the respond number 1 to 3.
1, 2, and 3.
Lordship 4 is a performer respondent.
We are not interested.
Lordships.
Absolutely not interested.
Lordship.
Petitioner in this petition has challenged, has sealed a show cause notice issued under section 73 within bracket 1 RW section 50 of the Assam GST Act 2017 issued on 11/1/2024, whereby a petition has been called up on the show cause within 30 days from the date of receipt of the show cause notice as to why an amount of rupees 27,25,503 bracket of break up to 47 should not be recovered from the petitioner, being the input tax credit excess claim for the period 2018-2019 plus interest and penalty. Full stop. The petition has a seal received show cause notice on the ground that the petitioner had availed ITC on valid tax invoices raised by the supplier and have also made payment of tax to the supplier. Full stop. Reliance has been placed in the decision of the Honorable Supreme Court of India in Union of India versus Bharti Airtel Limited. Reported decided on 28/10/2021, as well as the decision of the Honorable Calcutta High Court in the case of Suncraft Energy Private Limited and another versus the Assistant Commissioner State Tax. What is the page?
Lordship, Suncraft judgment page. Lordship, it is at page 112.
Page number?
112. 120.
Page number 122.
1122.
Bracket or लिखित.
117.
117. On the other hand, Mr. Chaudhary, learned standing counsel, finance and taxation has department has submitted that. The show cause notice has been issued after considering the instructions in circular 183/15/2022 dated 27/12/2022. More particularly, clause 4.4.1 thereof. The matter would require further examination as for the parties. This is the case on 22/02/2024. Full stop. Having considered the submissions of the land council for the petitioners. It is observed that the respondents shall not act upon the show cause notice, impugn show cause notice dated 11/1/2024 till the next date of listing.
Grateful. 20 I appear for the petitions.
Okay. What is here?
Lordship,
Show
here-
cause.
No, Lordship, here, section 168A, force majeure. Lordship, what happened during 2020 when the COVID struck in? By the taxation ordinance, the government introduced section 168A to the CGST Act and the Assam GST Act. That 168A provided that the government in such cases of force majeure may extend time limits of compliances by the department as well as for the SSC. Now, Lordship, certain extension notifications were issued from time to time. For 18-19, financial year 18-19, Lordship, as per the provisions of the law, the last date to issue show cause notice was 30th of September 2023 under section 73. and to pass a demand order therein, it was 31st December 2023. What did the CBIC did on 31st of March 23? They came up with a notification 9/23, wherein they extended without saying any reason as to the time period for 18-19 for the government to issue a show cause was extended by 3 months. Notification 9/23, Lordship, dated 31st March 23, the notification stated that on the recommendation of the council, under the powers of 168A, the time limit to issue a show cause and an assessment under 73 for 18-19 is extended by 3 months. Now, Lordship, the question is whether this extension under 168A, because 168A was a very important provision brought in only in the times of COVID. Now, taking that reference of 168A, what the reason behind that extension of 3 months has not been specified. So, Lordship, whether this notification 9/23, under which the department is blatantly issuing show cause notices on the last day of the due date, extended due date, is before your Lordship. And Lordship, four division benches of various high courts have passed an order asking the petitioners to participate in the proceedings, but there will be no order passed. So, Lordship, in our case, what happened? And Lordship, this was the first ground. Second ground, Lordship, your Lordship judgment in PepsiCo, when your Lordship was given a stay, that 21st December 23, they directly issued me a show cause referring to scrutiny of returns. Section 61 deals with scrutiny of returns. Then there's a self-audit 65, 66, and then 73. Your Lordship that categorically held that that process of the law has to be followed. It's an interim order, Lordships. In my case, I also rely on that also. These are the 2 points before your Lordships.
What are the documents?
Lordship, the show cause, the notice
168A.
that is at page 8, Lordship. I have extracted that in the petition. Page number 8. May I please refer, Lordships. Powers of government to extend time limit in special circumstances, 168A, subsection 1. Notwithstanding anything contained in this act, the government may, on the recommendation of the council, by notification, extend the time limit specified in or prescribed or notified under this act in respect of actions which cannot be completed or complied with due to force majeure. The power, subsection 2, the power to issue notification under subsection 1 shall include power to give retrospective effect to such notification from a date not earlier than the commencement of this act. Explanation. For the purpose of this section, the expression force majeure means a case of war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature or otherwise affecting the implementation of any provision of this act. Now, Lordship, under this power, the impugned notification 9/23, which is at page 45. Yes. Page 45. No. Notification number 9/23, central text, dated 31st March 23. In exercise of the powers conferred by section 168A of the Central Goods and Service Tax Act, read with section 20 of the IGST Act and section 21 of the UTGST Act, and in partial modification of the notifications. Lordship, there are various notifications. I am skipping that, Lordship. Serial number 1. For the financial year 17-18 up to 31st December 23. I am not on that, Lordship. Serial number 2. For the financial year 18-19 up to 31st day 24 March. Now, Lordships, kindly comes again to the notification.
Extends the
Lordships. Extends the time limit specified under subsection 10 of 73 for issuance of order under subsection 9 of section 73 of the Act for recovery of tax not paid, short paid, input credit, wrongly availed, utilized relating to the period as below. My period concerned, Lordship, is 1890.
This is regarding extension of time period for passing order.
Lordships, now kindly comes to 7310. Lordship. In the Act, Lordship, they have defined it like that. Show cause to be issued within 3 months before passing the order. Lordships, my Lordship, may I place 73 1 and 2 first? Because it deals with show cause. Lordships, section 73 1. Where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than the reason of fraud or any willful misstatement or suppression of fact to evade tax, he shall serve notice on the person chargeable with tax which has not been so paid or which has been so short paid, or to him the refund has erroneously been made, or who has wrongly availed or utilized ITC, requiring him to show cause as to why he should not pay the amount specified in the notice along with interest payable thereon under section 50 and a penalty leviable under provisions of this act or rules. Subsection 2. The proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of order. Now, Lordship, I take you to section 7310. The proper officer shall issue the order under subsection 9 within 3 years from the due date of furnishing of annual return for the financial year to which tax paid, not paid, or short paid, or input tax credit wrongly availed or utilized relates to, or within 3 years from the date of refund. Lordship, annual return is the cut date. I'll again place this, Lordship, section 7310. Proper officer shall issue the order under subsection 9 within 3 years from the due date of furnishing of annual return for the financial year. Lordship, annual return is dealt by section 44. It specifies the time limit to file annual return is December of the next year. Means for 17, 18, 19, it is 31st December 19. Now, this, because of COVID, this got extended. For 18, 19, which is my concern, financial year, Lordships, the last date to file annual return was 31st December 2020. So 3 years from 31st December 2020, they can pass an order, which is 31st December 23. Lordship, 31st December 20 was the annual return date, extended. 3 years under 7310, they have to pass an order for 18-19 within 3 years of 31st December 20.
Your case is 1890.
18-19, Lordship.
Then what will be the last date for submission of annual return?
31st December 2020. It was the last date. So 3 years would be 31st December 23. So to issue a show cause, it would be 3 months before 31st December 2023 as per 73(2), Lordships. 73(10), Lordships is saying for the order. Last date to pass an order for 18-19 was 31st December 2023.
Okay.
Lordships.
31st December 2023.
Which as per the notification impugned has been extended to 31st March 24 in serial number 2, Lordship, page 45. Now, Lordship, as a corollary of this, show cause notice to be issued 3 months prior to this, as per 73(2), Lordships. So, original date to issue show cause was 30th September 23. By this 9/23, they extend this 30th September 23 to 31st December 23 for show cause. And they refer to 168A, which is only for force majeure.
Okay, Passing the order is up to 31st.
March 24.
Okay.
So show cause 3 months, 31st December 24.
31st December.
This is the extended time as per this notification. The original time expired on 30th September 23. So they bring out this notification 9/23 under 168, your lordship. 168, your lordship has seen at page number 8, it specifies only force majeure. Page number 8, lordships. And it defines force majeure.
Now, when
The show cause is issued to me. 21st December 23. Under the extended timelines. And lordship, I'll take you this, the 168A, the very challenge is, lordship, this 9/23 is issued under 168A. 168 is very specific to force majeure. The notification nowhere space what is force majeure.
so you are challenging this notification.
Lordship, I am challenging the show cause notice which has been issued under this notification.
You are challenging this notification.
No notification also, yes. But lordship, as a consequence, it is my show cause which is hampering me.
If it does not stand, so cause will not stand.
Lordship, I vote on to you.
But if it stands, then so cause
Stands. Lordships. Lordships, I vote on to you, lordship.
So what is the
Judgments of
judgments
lordship.
on that
Finally
point by
come to
other high courts?
Lordship, page 81.
Lordship, just for clarification, there is a notification of the registry that any rule or act has been challenged, that should be entertained by the division bench. Today also item number 4 was there before court number 4.
Okay.
Same provision.
Lordship, it is not a rule or act. It is a notification.
Lordship, another section 16.2 and 16.4 already challenged and pending before this honorable court. 16.2 and 16.4 because
What is
lordship
16.2?
16.2 is lordship.
That is statutory provision.
Yes.
We are not on.
Sorry. May I clarify? I'm wrong.
No,
May I clarify? Lordship 16.2, it says, Lordship, may I please to see.
16.2.
May I come to page 48, Lordship. This is a prayer of part of the demand and show cause notice. Below 1.
Page 48.
Page 48, Roman 1. Ineligible ITC received from supplier who have not filed.
Page 48, which paragraph?
Last two, Roman 1 and 2.
ITC amounting to.
Ineligible ITC received. This covers under section 62.
1 minute. Page 48.
48 below lots.
Below.
Roman 1.
Roman 1. Okay.
Ineligible ITC received from the supplier who have not filed their ESTR 3B returns amounting to rupees so. Then 2. This covers under section 16.2. And B 2, it's covered under section 64. Let's say please to see. ITC amounting to rupees so which become ineligible in terms of section 16.4 CGST.
This is against so called. Whether this case 45, this notification.
Yes, sir.
If a challenge is made to this kind of notification, it is to be before the single bench or
Division bench, sir.
I don't know.
In my submission, because today
I am not aware.
I am not brought out, not with the notification is not me at present, not with me. I can produce that notification.
If your lordship
is
yesterday,
It
lordship.
is a matter of jurisdiction and this is that is a different matter.
Lordship, generally what we do in other high courts also this matter was taken up. Whenever there is a wires challenge, constitutional validity of a provision, then it is. Lordship,
I don't know. But if there
Of
are
course, Lordship.
notifications, then we are helpless.
Today, similar type of petition was there before court number 2, item number 4. That was placed before single judge. Then it was referred to division. And lordship, basic challenge of the petitioner is under section 16.2 and 16.4. Probably, if I'm wrong, my.
Lordship, I'm on 168A. That is what I've addressed my lordships also. 168A and your lordship judgment in PepsiCo. Whether the process as prescribed in the law is to be followed or not.
And lordship,
No,
recently.
there the procedure is
Lordship, I've
the rules and
Lordship, that I've referred in my pleadings also and I've attached the judgments also.
no, if there is a challenge to this kind of notification, which is exercised by exercising statutory powers conferred under section 168A, whether this kind of challenge is to be considered by single bench or division bench, I'm not sure.
Earlier it was there, subsequently it was new notification come up.
Then if it is a notification, then I can't help it.
Even earlier,
If such kind of notification is there.
earlier section 174 was challenged before decision of court. That was decided was simple there, Lord. But subsequently new notification has come. Now all the cases are.
Okay, then you will not be there. We'll examine. When can you produce the
On Friday, Lord.
Friday?
Look, can I
Take
appear
anything.
virtually, lordships? Can I take leave to appear virtually?
Notification will be provided to your assisting counsel.
Lordships.
Then we'll see.
Lordship.
If it is to be before division bench, then it is to be before division bench.
Lordship, now the only difficulty is again the reply to the show cause. Till that time, some protection may be given. Otherwise, Lordship, where do I go? I have taken my Lordship to the prima facie of the fact case. Now, the question whether this honorable court is by the jurisdiction of this honorable court, Lordship, that is not under my control also.
That is also not in my control.
Lordships.
I have to examine.
Lordships.
That order is to be on, will consider that aspect on Friday. Right. Whether there is any provision in the GST Act that suppose any period which is under stay, it gets extended. Suppose something is under stay of a court.
Lord, it is there, section 76, 75 and 76. It is there. That is covered. Department is very well covered by that.
So for you also.
If the court says no, you go down again. So it is for the department that they can.
No, if we say if we
Lordships
negate your challenge, we can extend the time period also.
Grateful
To reply to your so-called notice.
Yes.
Okay, Mr. A. Kanodi heard for the petition and Mr. S. C. Kyle, I'm standing out the GST. So Mr. Kyle, when standing out the GST has submitted that as a notification issued under section 168A of the CGST Act 2017 has been challenged in this petition, the matter, the petition is to be considered by a division bench. So stop. To support his submission, he has sought listing of the case on Friday to produce the relevant notification.
Till that time, my learned friend be instructed that no course of action will be taken.
Lordship, we seen yesterday, day before yesterday, one matter come notice was issued in November. Till date, they didn't file.
Lordship, it is about.
Let it be on Friday.
All assets are Lordship level.
If notification is there, then we have to send it to the division bench.
Grateful. Grateful to Lordships.
I think 21.
Okay, 21.
I know 21.
Yes, my lord, it's about mutation of name of a person, but how mutation is going to affect me and what kind of practice is going on generally in the office of the circle officer, that I want to apprise this honorable court so that appropriate relief can be granted. What has happened, my lord? Particular patta, it contained 3 bigha, 2 lassa of land. My father purchased 2 bigha of land. Subsequently, my father prayed for creation of a separate patta, that is by way of partition under section 105 of Assam Land Revenue Regulation. He was allowed and he was allotted a different patta. So when his land measuring 2 bigha was brought out from the original patta, what remained in the original patta was 1 bigha, 2 lassa. Because out of 3 bigha, 2 lassa, my father purchased 2 bigha, got it out in a separate patta. So the area of land which remained in the original patta was 1 bigha, 2 lassa. Thereafter, one of the pattadar, how he approached the circle officer, we don't know. And he got his name mutated against 2 bigha 2 lasa, which is not there in existence in the particular patta. Now, this kind of practice is generally going on, my lord. After, at one point, one illegality is committed by the circle officer. Now he has mutated 2 bigha 2 lasa. After 2 years or 3 years down the line, the same person will approach for creating a particular new patta that will be allowed. And subsequently, he will allege that my 4 boundaries persons have encroached my land. Now kindly measure. And a day will come when he will come along with the circle officer in my particular plot of land. I submitted a representation. This is the kind of practice generally going on, not in one beat, but beat by beat it is going on in different circle office. But my application representation has remained unattended. Kindly see 3 documents, my lord, though I have annexed many. Kindly come to, my lord, Annexer 4, which starts at page, my lord, 20, English version. Annexer 4, my lord, will show that dag number 470, there are total area of land 3 bigha 2 lassa. Now kindly come to page 22, my lord, same patta. Name of my father is appearing at column number 6, Abdul Qasim. Now kindly come to Annexer 3, my lord, page 18. From the earlier patta, my father got his name carved out and got his new separate patta created, 2 bigha. Now what ought to have remained in the remaining land, my lord, kindly come to page 24. Lordship will find total area in the entire dag is 1 bigha 2 lassa. Up to that extent, it's fine, my lord. Now kindly come to page number 27, my lord. The remarks column, 3rd paragraph. Mr. Anishur Rahman, against his name, your lordship will find 2 bigha 2 kattha. Right side, my lord. Page 27, right side, 3rd remark column, the last column. In the middle portion, your lordship will find name of Anishur Rahman, and below his name, an area of 2 bigha 2 kattha has been muted, whereas the entire patta, whether your lordship has traced that, the entire patta has only 1 bigha 2 lassa. But this gentleman has got 2 bigha 2 kattha. Where from, on what stand? It cannot happen, my lord. When the total area of land covered under patta is 1 bigha 2 lassa. Thereafter, my lord, we submitted one representation because this is not the isolated case that is going on.
Have you got this order 26/11/2021 order?
That order is not available, my lord. They have passed, but it is not available for us. Thereafter, we submitted one representation, my lord, on Annexer 6, my lord, page 34. As soon as we come to know about this, because generally what happens, my lord, what is going on in the office of the circle office, my name is mutated, why I should keep looking into the mutation of others? But I was hearing something going on in the office of circle officer that something is going on and this kind of practice is going on. Thereafter, I started monitoring my own land. When I came to know about this, I submitted this representation to the Commissioner, Revenue and Disaster Management along with the DC. This is not the isolated incident that has happened, at least in my case.
No, you are protecting your cause. That's
Yes,
all.
right.
Now, you are saying that you have not got this copy of the order.
My lord, and this representation has remained unattended. The basic question is where from 2 bigha 2 lassa can be mutated when the entire Dag doesn't have that much of area of land. The Dag has only 1 bigha 2 lassa, whereas the person has
Let
got,
Mr. Henry produce this copy of this order 26/11/2021.
along with affidavit, my lord, as to how this has happened.
Records pertaining to this. Petition order or whatever order.
My lord,
26/11, come to page 32.
Lord, 32.
Remarks column. Second one.
Lord.
Tuka.
Lord.
Last bundle.
26/11/2021.
Tuka. Read. Tuka last bundle. Sanjeev Modoi.
সঞ্জীৱ মুদৈ
Anisur Rahman. Bibur.
পিতা নামৰ সংশোধন কৰি আনিছুৰ ৰহমান
2
পিতা
বিঘা 2
হাবিবুৰ
কথা।
2 বিঘা 2 কথা কৰা হ'ল। প্লাটফণ্ডৰ প্ৰতিবেদন চোৱা হ'ল। সংশোধনীৰ বাবে অনুমোদন দিয়া হ'ল। চক্ৰবিষয়া পংকজ বৰা।
To get the records pertaining to this. That's all. Will issue notice? Or will
It
it-
is a notice.
Third, Mr. S.K. Singh, Senior Counsel, assisted by B. Pusila, counsel for the petitioner. Mr. J. Hendy,
For 2 and 3 lordships.
okay, Z. Hajorika. Learned Standing Council Revenue and Just 1. J. Hendy, Learned State Council for the respond number 2 and 3. It is the case of the petitioner that originally, tag number 470 of patta number 1 old 68 new of village Gotlang. Yes, put revenue circle. Contain a parcel of land measuring 3 bighas 2 lesser. Full stop. The father of the petition, comma, Mohammed Abdul Qasim, purchased,
My lord,
purchase a part of the said land measuring 2 bighas and a separate patta, separate dag number and patta number for said 2 bighas of land, purchased by the petitioner's father, was allotted by tag number 666 and patta number 208. So after purchase of 2 bighas of land by the petitioner's father, the land area remained under old dag number, under dag number 470 and patta number 60. Patta number 1, 68 only, 68 only, huh? 68 was 1 bigha 2 katha.
1 bigha 2 lassa, my
2 lesser. But by an order dated 26/11/2021, the respondent number 3 corrected the land records in the name of the respondent for an area of land measuring 2 bigha 2 katha. The petitioner has raised an apprehension that because of the mutation of the dated 26/11/2021, the petitioner's plot of land measuring 2 bighas is likely to be adversely affected. Hence the repetition. Issue notice returnable on the 6th. Mr. Henry Leonard, State Council has submitted that the issue will be cleared if the relevant records leading to the passing of the order dated 26/11/2021 by the respondent number 3 are examined. Issue notice. Mr. Hendrik, Lion State Council shall make endeavor to produce the relevant records pertaining to leading to the passing of the order dated 26/11/2021 on the returnable date. Apply. Issue notice. Extra copies.
Item 50.
May I please, Your Lordship. My lord, is senior counsel, Mr. PJ Swiggy is not well, Lordship. My lord, matter may kindly be taken after
No,
one.
somebody you have
Uh,
filed
We have filed in one small additional affidavit today.
Mr. Hussain will issue notice, will fix a date, we can dispose of. 5-10 days,
Lordship,
7
because
days.
of the content, if your lordship may kindly have the additional affidavit for once. I'll just reflect the present position that we have filed today. What has happened, your lordship, is that initially the petitioners, for whatever reason, had stated that eviction was complete. Now, your lordship, because there is a stay on the eviction process, again, fresh encroachments have taken place in the entire area. We have annexed the photographs, your lordship, this is an area inside the reserve forest, which your lordship will find at page number
You have filed the affidavit.
We have filed the
Right.
affidavit. Yes, your lordship.
Lordship, may kindly see the photographs, Lordship. They have just taken shelter after their houses were demolished, Lordship. Lordship, kindly see.
We have not issued notice. We like to issue notice next Monday, we can dispose.
Very well. Very well.
Lordship, on 15, Lordship. On 15.
15,
Lordship, on 15.
not 15, 16.
Lordship,
16.
Lordship, because we are also facing suo moto contempt before a division bench, your lordship.
Make a mention, maybe we will dispose of on 16.
Very well, your lordship.
One thing, your notice is very,
It should have been fleshed out, your lordship. It is very vague, your lordship.
this is one thing.
That is one
weak link.
That is one weak link.
Because in respect of others, division bench has passed orders in due process of law.
Yes.
And that has been explained by Supreme Court.
Yes, due process has to
What
be.
kind of due process
Yes, your lordship.
should be required?
Yes, your lordship.
There is nothing in the notice.
Yes, your lordship.
Something, that is why I asked for that notification
Yes.
declaring forest.
Yes. That is now on record.
Purpose behind it.
Yes, your lordship. That is now on record.
Heard Mr. M.I. Hussain. Learned counsel for the petitioner, Mr. K.P. Pathak, learned standing counsel.
Yes, sir. Yes,
Forest
sir.
Department.
Forest Department.
The respondent number 1, 2, 3, and 5. And Mr. J. Henry, learned junior government advocate Assam for the respondent number 4. Two affidavits, two counter affidavits have been filed on behalf of the state respondents. Full stop. Let notice be issued, returnable on 16/2/2023. The petitioners, if the petitioners want to file any reply to the said affidavit, they may file it on or before 15
Very well.
to 2024. As when so appeared except liquidivo, no formal notice liquidivo. And the interim order passed earlier shall continue till the next date of listing with the observation that an endeavor will be made for final consideration of the repetition.
Deeply.
My lord, name of the senior counsel may be shown in the cause list.
Senior counsel name is not required to be shown. There is no law. Obliged.
Item number 51.
Yes, Mr. Vishwas.
My lord, the matter relates to the acquisition of the land under Mala project. We have made representation against the price they are offering, but it has not been disposed of, our representation. My lord,
They are offering a price
yes,
and you are not accepting the price.
not accepting the price.
Matter is there.
My ready to.
Yes, Mr. Hendik and MS Hazarika. You are offering a price.
Lordship.
They are not accepting the price. Matter is there. Then the provisions of 2013 is to be invoked. Or did you submit any consent form?
Yes.
You have submitted consent form.
No, consent form. I have not submitted.
Then, my lord, they file a petition.
My lord, your lordship has on a similar case already passed the judgment. I take your lordship page 72. Exactly similar case of the same district.
So there, I think. So here you are asking for more money,
Yes, more money.
more amount.
Yes.
They are offering one,
Yes.
right?
So they're very
This
below.
notification, Mr. Vishwas, is on the basis of mutual settlement or mutual
Mutual,
agreement.
sir, exactly.
Right.
It is the
Now, what
idea.
is mutual agreement?
They are not giving
They
it,
are offering a price. You are not accepting it.
but they are giving
Simple.
a very small price, which is more.
Oh, we cannot force. They are offering a price on the direct purchase method, and you are not accepting it. Matter is there.
But they are not releasing. They said we will accept your, we will take up your
No,
land.
then we'll say that since you are not accepting it,
I'm not accepting because
then this process should be dropped. Mr. Hendik, this is a notification which envisages direct sale and purchase on the basis of negotiated settlement. That so that the process can be faster.
Lordship.
You are offering a price, say 4 lakh. They are asking for 10 lakh. Where is the question of settlement?
Lordship.
Then you have to go
For
the acquisition process.
Lordship.
As simple.
Lordship.
Take your instruction.
Lordship.
If you are interested to give them 10 lakh, that's all.
That's all.
If the deputy commissioner is agreeable, or otherwise take the instruction, we'll close this.
Lordship.
And we'll observe that now, since there is no mutual settlement between the parties,
Lordship.
the provisions of section 213 Act are to be resorted to. That's all.
Let me
Anything?
take instruction. Lord.
Take instruction.
yes,
They are offering what?
they are 4 lakhs. I pray that
Per kotha or per biga?
similar land has been sold out at 10 lakhs.
That is not settlement or mutual agreement. Tell me, what is your demand?
I want the reasonable fair price. That is the fair
That-
price.
We are not here.
Well, if they give, pay us very below of the adjacent land,
Mr. Biswas, we are not here to do
yes, very true. But they should-
simple.
They remain
Yes or
tight.
no, that's all.
Doing advancing, we have made representation. They are not calling us.
Tell me, what is your price?
My price is 10 lakhs per bigha,
And they are offering?
4 lakhs.
Heard Mr. S.C. Biswas, Landed Council for the petitioners. And Mr.
I'm for S1 number 3.
G. Hazarika. Public, Mr. H. Barua, Land Council, representing P. Gugui, Standing Council, PWD for the Aspan number 1, G. Hazarika, Land Standing Council, Revenue 2, Mr. J. Henrik, Land Junior Government Advocate Assam for the respondent number 3, 4 and 5. Age Burwa 6 to লিখে দিব. Full stop. The case of the petitioner is that their lands, patta lands,
Yes, Patalan.
are sought to be acquired by the state respondents under the
Assam Mala program.
by way of direct purchase method. Direct purchase by way of negotiated settlement method, framed under the notification dated 20/01/2021. Full stop. The state respondents are offering, according to petitioners, the state respondents are offering
Offering 3,06,000.
3 lakh
6,000.
6,000
Yes.
per
bighah.
bighah.
Yes.
In respect of the petitioner's lands. So the petitioners have claimed that the market value of the petitioner's
10,50,000.
lands are
10,50,000.
is 10,50,000 per bighah. Full stop. As per the direct purchase by way of negotiated settlement method, the same can be proceeded with only if the owners of the land agrees to sell the land at the price offered after negotiation. Full stop. Price offers. Full stop. As per the scheme, in the event any other owner refuses to sell the land or any of the owners has objected or not interested with the direct purchase through negotiation, the respective land can be acquired through the acquisition process of the Assam right to the right to fair compensation and transparency in land acquisition, rehabilitation and settlement. Assam right to rules 2015. Framed under the provisions of the Right to So and So Act 2013. So, Mr. Hendrik, Learned State Junior Government of Assam, paying for the respondent number 225, 234, sorry, 3, 4 and 5 has sought in which time to obtain instruction as regards the price offered by the state respondents for the petitioner's piece of land. The as to it and as to find out Mr. Hendrik has further submitted that he'll obtain instruction as to whether there is any possibility to explore there is any possibility for any negotiated settlement in respect to the
Date may be fixed.
Release the case on 16.
Under item 19 is the same. They have not yet taken 31. They have not yet taken an instruction. Your Lordship has issued the notice. Item 31.
31.
Yes.
Okay. As SC Visas, Council Board of Petitioners, and Mr. J. Hendrik, Lion State Council.
31 Lordship.
Okay, then we will take up.
Okay.
With my learned friend served the extra copies to me.
I'll give my, why not?
Mr. Biswas, learned counsel for the petitioner shall furnish 2 copies of the petition along with annexes to Mr. Handy by tomorrow. Yes.
Item number 52.
May it please your lordship. Malana, the management, earlier management got dissolved because not holding the AGM. We approached the court and the court passed an order. The relevant portion is at page, my lord, 21, paragraph 8.
21.
The judgment starts at page 19 and 21, paragraph 8.
Who are the petitioners there?
One of the shareholders now.
Shareholders.
Now shareholders.
What was the observation? Paragraph 8?
My lord, present petitioners are the shareholders. During that time, it was the
No,
directors.
these page 16 order,
My lord.
who were the petitioners there?
My lord, the petitioners were one of the directors. The board.
Directors of the society.
Society.
Okay. Paragraph 8, on a consideration of position meeting. Resolutions adopted to hold the AGM, but not granted.
Because of the COVID ballot, AGM could not be here. So that disqualification was allowed to be allowed. The disqualification would not make them ineligible for contesting the election. That was the order passed one. Now, Malad, thereafter, Malad, date was fixed to be held on page 23, Malad. This was the executive officers, SS Limited. They have passed this notification on 4th July 23. Thereafter, Malad, date was fixed on 16/7/23 for election. And Malad, because of a defective list, again the shareholders approached this court. And the judgment is at page 24. And the relevant portion is at page 26, para 5. Lordship has got it. Page 26, para 5.
No, who are the petitioners there?
But the shareholders. Mahathir Ali Pradhani and others.
That petition number 1, he moved a petition earlier.
Malad.
Just 2 days before. Pradhani, I only remember Pradhani.
Malad.
Same society?
Same society. Now the shareholders, Malad, at page 20.
Today also one petition is moved.
That same society.
Same society.
Same society.
Maybe Malad. Malad, page.
There were, I found 2,000, more than 2,000 shareholders in this society, in the earlier petition.
Malad.
And 100 persons have submitted a representation.
Malad.
First representation, vague. Shareholders. Second representation, that 3 persons are wrongly included. And election is scheduled on 9th.
But against not defective list I have come. Here.
9th.
8.
Oh, that council said 9th.
8 to 20.
So I say that 2,000 shareholders, only 3 persons wrongly included.
I
They're
am
not
not against defective
going to
shareholders.
stall.
I am not against defective shareholders now. Page 28 is the order of the register. After the repetition. After perusal of the records and hearing the parties, I directed the Assistant Register Cooperative Society to correct the voter list of such and such in consultation with the petitioner and hold the election immediately. This was the direction from the register. Your Lordship has got it. Now, my lord, there is the notification at page 31. I am against page 32. Page 32. Your Lordship has got it. As per section 42, the Assam Cooperative Society, the candidates who decide to contest the election of the board, post of board, he has to attend at least 2 annual general in the previous 5 years, and his signature must be attendance register of agent. That was already decided.
It is by secretary. It is issued by secretary.
Secretary, Malad.
But that is,
Now, Malad, this
that is
notification,
as per this.
I have filed a representation saying that I may be allowed to contest the election. That much is my prayer.
No, if you are fulfilling this condition,
My only thing is that election AGM did not held because of COVID. It was already decided by this court.
Mr. Rochuri, it was on 4th July 2023. Everything has been decided.
In 24, Malad,
4th July 2023, everything has been decided.
Malad, 4th July 23.
Page 23.
Yes, Malad.
Everything has been decided.
Sir, that much.
It is a reiteration.
But now they are saying that you.
Reiteration, only reiteration after 6 months.
What they are saying that you have to, that without that AGM, you cannot contest. Because you have not participated in the AGM, you cannot contest. They are saying at page 32.
Huh?
Page 32, as per section 42, the Assam Cooperative candidate who desired to contest the election for the post of the, he has to attend at least 2 annual general meetings in the previous 5 years.
Now come, Mr. Rochuri, come to page 20.
Page 23.
Page 21.
21. Malad.
I don't know, but still it is holding the field.
Malad. Yes, Malad.
The erstwhile members of the board of directors,
Malad.
including the petitioners, would not suffer disqualification, and they will be entitled to participate.
This is what I want.
No, no.
This is what I want.
Right. You are the erstwhile board of directors.
No, man, I'm the shareholder.
Oh, then don't try to
say
say something. Only court has asked, allowed.
The shareholders.
No.
The board of directors. Correct, man. Board of directors. But only thing, my lord, when it is an admitted fact. Election did not help. AGM did not
I
help.
don't know. I am not tasting the. I am not making any comment.
Because
about page 21.
Page 21.
Page 21.
Paragraph 8.
But by mandamus, a statutory provision cannot be read down.
Malad, 130, Malad, that because of that COVID-19, it was.
You are shareholders, Mr. Raichuri.
Now, Malad, here in this election.
You are a fence-sitter.
Malad, here, Malad, now this.
Page 21, it is clear. I am not saying anything.
Malad, this notification.
Yesterday said, Supreme Court, reading down a statutory provision is beyond the writ of mandamus.
Malad.
I am not saying anything more. But by this page 21 order, only the erstwhile directors were allowed.
Correct, my lord. Now this notification.
And this authority, secretary of a cooperative society,
has issued
does not wield any statutory power. What is staring on your face,
my lord,
is the statutory provision.
My lord.
Let us read.
My lord.
Somehow they got the benefit by page 21 order. Paragraph 8, you are not amongst those.
Correct.
Right?
My lord.
You are shareholders.
My lord.
You will be governed by only.
If your lordship permits me to say one thing, my lord. During that COVID period, there was no AGM held, my lord, because of the restrictions. It is an admitted fact that during that COVID, there was no election AGM.
This is what I am saying.
my lord. There was a
Without making any comment
my lord, my lord,
on the order
my lord,
passed in paragraph 8
my lord,
of this order,
my lord,
if we look at the law
my lord,
and the power under each jurisdiction,
my lord.
you want that one statutory provision is to be read down.
My lord. My lord, what I want to
They
place
have
is
got the
this,
benefit, Mr.
because during that time in the COVID provision.
Because you have not challenged that order by way of writ appeal or seeking a review.
My lord,
What is the eligibility
section one,
to contest for the post of
eligibility, section 40.
section 40?
Eligibility for a director in cooperative society.
Is there any condition for a member? Okay, it is member subject to the section. Has attended at least two annual general meetings in the previous 5 years.
There was, because of COVID, my lord, there was no AGM. There was a special notification by the central government.
What did you do since 20?
Because now the
20 or-
notification has come now, my lord.
No, notification is 4 July 2023.
24/1/24, page 5,
No, no, this is the notification, page 27,
No,
23.
page 31. Page 31 is the new notification come, 24/1/24. 24/1/24. It has come on January, my lord, for the election to be held on 8/2.
Okay, you make submission on your interim prayer. We'll
My only
consider.
my submission
We
is,
are considering
but I am on my, that, my lord, section 130, my lord.
on the basis of this order.
Which order, my lord?
On the basis of this page 24 order, we have to consider, right? Because the election is scheduled on 8/2.
24 order is only.
More mobile will available. Because you want to get the benefit of that page
Page
13/7 2000. Sorry, not 13/7.
My lord, I want to get,
19/6
my lord,
2022.
I want to get the benefit of page 23.
Right.
To therefore to maintain cooperative democracy and
No,
to provide natural
Page
justice.
23 is passed by secretary.
No,
He cannot override the provisions of section
40.
40. Now, next question is,
Executive, this was executive officer, but
he is
my
paid
lord,
employee of the cooperative society.
my lord,
Right.
my lord,
He is a paid employee of the cooperative society. Yes, Mr. Abdullah?
Yes.
Is he not?
my lord.
In absence of the board, my lord, he is just deputy.
One-man committee, one-man committee
no
was
power.
And he is not the executive officer. Okay, executive officer. But question is, page this order, 19/6 2023.
19/6.
Page 19.
Your argument is that since the directors of the erstwhile board of directors of the society
My lord.
have been permitted to contest the election,
My lord.
so you should also be made.
My only submission, my lord, to the honorable court is this: when AGM could not be held due to COVID, during that time limitation was also
Right.
excluded.
Right.
That was excluded, and this AGM could not be held due to COVID. It is
Right.
an admitted fact.
Right.
So, my lord, now, because they want to say that you have to attend within 5 years, attend 2 AGM.
No,
When
they are not saying.
It was by the notification.
This book is saying.
Book is saying, my lord. But during that time, my lord, everything was taken care of by the central government notification of the COVID-19. It is a situation fact.
Central government notification is about limitation.
Limitation, but In many of the cases, my lord, when because of the 50% could not be attended in a particular place during the COVID, my lord.
Heard, Mr.
My lord, only thing, page 35, immediately after on the notification issued, I filed a representation. 25/1/24. Immediately on that. My lord, there was no.
Okay, we are examining on the basis of the statutory provisions and constitutional parameters, that only. We are not examining the steps taken by some secretary of a cooperative society.
My lord.
We are not here to decide the action of a cooperative society secretary.
My lord.
We're not here. Heard, Mr. P.K. Roy Chaudhary, learned counsel for the petitioners, and Mr. S.K. Taluja, learned standing counsel.
1 to 6.
Corporation Department for the
Report
respondent number
petition.
1 to 6. Full stop. The petitioners, obtaining numbers, ours have stated that they are shareholders of Messrs.
Madhu Solmari.
Madhu Solmari Homobai Committee Limited, Kauripur District, Hubli, a cooperative society registered under the provisions of the Assam Cooperative Societies Act, 2007, within bracket the 2007 Act, and or the Act 2000. Full stop. The case of the petitioner is that during the period of COVID-19 pandemic, the erstwhile board of directors of the society failed to hold annual general meetings in terms of the provisions of the 2007 within the stipulated period, as laid down by the provisions of section 40.
My lord, 40. My lord, it is the election
39.
41/3.
39.
39, my lord.
Section 39 and section 41.
41.
Of the 2007 Act, which required holding of the annual general meeting within a period of 6 months from the close of the financial year.
Well.
Full stop. As the erstwhile board of directors of the society stood dissolved, the members, the members of, the directors of the said board of directors of the society approached this court by a writ petition, WPC number 1851/2023, on the apprehension that they would incur disqualification to contest the next election to the board of directors of the society in terms of the provisions contained in section 40 of the 2007 Act. Full stop. The said writ petition, WPC number 1851/2023, was given final consideration on 19/6/2023. Full stop. By the order dated 19/6/2023, the writ petition was disposed of, was allowed by providing that the erstwhile members of the board of directors would not suffer disqualification as provided under section 40 within bracket 4 within bracket small a and small e and section 41 within bracket 4 of the 2007 Act, and they would be entitled to participate in the ensuing election to the board of directors of the society. Full stop. Para. Mr. Rocheri learned. Full stop. Issued notice returnable on 6/3. The petitioners hearing have essayed a condition laid down in the notice, in a notice dated 24/01/2024, whereby it has been notified jointly by the executive officer and the secretary of the society that the general meeting stroke election of the society would be held on 8/2/2024. Full stop. As per the impugned condition, comma, only those candidates who had attended at least 2 annual general meetings of the society in the previous 5 years and their signatures were in the attendance register of the annual general meetings would be allowed to contest the election to the board of directors of the society, taking into purview the provisions contained in section 40 of the 2007. Stop. Issue notice. Returnable on 6/3. 6/3. Mr. Rochuri and the counsel for the petitioners has submitted that as the petitioners hearing are shareholders, comma, they shall also be permitted to contest the election. They should also be allowed to file nomination papers to contest the election to the board of directors of the society, comma, scheduled on 8/2/2020. He has further contended that the petitioners are similarly situated like the petitioners in the writ petition WPC number 1851/2003.
Not similarly stated, my lord, because the AGM could not be held because of COVID-19.
The petitioner has, it has been contended that the petitioners could not attend the requisite number of annual general meetings during the previous
5 years.
5 years. Full stop. When the erstwhile directors of the board of directors of the society have been permitted to file nomination papers, comma, the case of the petitioners are required to be considered in similar lines. Mr. Talukdar, what is your submission? The said submission is opposed by Mr. Talukdar, standing counsel. Yes.
They stand on different footing.
And
The
the
case of
order,
the petitioner
the order passed by the honorable single judge is not, my lord, put to challenge,
is
my lord, in the
on,
writ appeal.
is on different footing. Full stop. By the order dated. Full stop. I have considered the submissions of the learned counsel for the parties. Full stop. As the provisions of section 40 of the 2006 are in the forefront of the list, comma, the same is put it here in the its entirety. Full stop. From the provisions contained in section 40 of the 2006 Act, it is noticed that a member of a cooperative society shall be eligible for being chosen as a director of the cooperative society only if he has attended at least 2 annual general meetings in the previous 5 years.
My lord, if your lordship permits me to say, section 130 is there. The state government by notification can exempt, my lord, section 130 of the act, power to exempt societies from the operation of the, my lord, the state government may by notification in the official gazette exempt a registered society from any or all the provision of some money. Under this provision, during the COVID-19, my lord,
Mr. Royshuri, we are not state government.
there is a only that, my lord.
4/7/2023. Everything was notified. You have annexed that notice.
My lord.
You are aware of the judgment.
My lord.
We are not state government. Don't equate the High Court with a state government.
I'm not placing that also, my lord.
Mr. Royshuri has also referred to the provisions of section 130A of the Act, by which the state government, in exceptional circumstances, can exempt a registered cooperative society from the operation of the provisions of section 39 and section 41(2) of the 2007 for a period not exceeding 6 months at a time, which can be further extended for another 6 months. After this, okay, we did it. By the order dated the writ petition, comma, WPC number 1851/2023 was preferred by 14 number of petitioners, projecting that they were the directors in the erstwhile, they were the elected directors in the erstwhile board of directors of the society. Full stop. The coordinate bench of this court
Page 20, my lord.
had observed that the erstwhile directors, elected directors of the board of directors of the society would not suffer disqualification as provided under section 40 within bracket 4 within bracket small a and e small e and section 41 within bracket 4 of the 2007 Act. So it was further, they were further given the benefit to participate in the ensuing election to the board of directors of the society. Full stop. It is noticed that after the said order, a notification was issued under the hand of the executive officer of the society on 4/7/2023, providing that all eligible shareholders for the shareholders also, mandatory 2 years attendance in the AGM during the previous 5 years would not be necessary. Full stop. Para. If the petitioner, in order to allow the prayer of the petitioner to participate in the ensuing in the election to the board of directors of the society, scheduled on 8/2/2024, despite the disqualification incurred by them under subsection 2 of section 40 of the 2007 Act would amount to reading down would amount to an order in violation of the statutory prescription contained therein. Full stop.
Lordship may say the embargo, my lord, in fact.
Embargo.
Instead of being a disqualification. my lord.
Embargo. Embargo. It is settled that a statutory provision the rule of reading down a statutory provision should not be applied ordinarily, and it can be applied only when such statutory provision cannot be saved from invalidation. Full stop. Thoroughly hope without commenting, without going into the merits, without commenting, no problem. So in such view of the matter, this court is not persuaded to extend any interim of relief to the petitioners, as sought for in this writ petition. So that I am making the ground clear, giving you a remedy.
My lord, only thing is this, my lord.
Since I am not inclined, so I have expressed my mind so that you
Ultimately,
can.
your lordship may dismiss it because it has become.
No,
infructuous.
no, it is.
It has
A
already
forum
become
is available.
Item number 22.
You can taste. You can taste.
Because, my lord, everybody.
So that you can participate.
No, my lord.
Just
Everybody
because
knows
I am not persuaded, that
COVID-19
does not
period.
mean.
COVID-19 period, nobody was able to do anything. Everybody was given a permission.
Right, I have considered. So I have something that so that you have an option door open so that tomorrow you can get the relief. I'm not closing the door for you.
Well, because the election held, everything become infructuous.
Appeal.
No, appeal, my lord, is not possible. It's not always possible to go for an appeal. But, my lord,
Otherwise, I'm not persuaded.
because only submission is this. It admitted fact, COVID-19, nobody took an AGM. And now only because directors and shareholders, some will be divided.
Mr. Roychuri, I'm not making comment on the order by which that directors were allowed.
No.
Right.
Because 130, there is a provision. There is a provision for notification.
So this court further finds that the provisions of section 130A of the 2007 Act is not found applicable in the case of the litigation. Yes.
My lord,
Yes,
by order dated
some
6/10.
undertaking, some submission was made. By whom?
By order dated 6/10, my lord, dear lordship.
Some, what benefits?
Earlier, there was an order from this court for creation of retrospective, for retrospective creation of post. They subsequently come with an IA with a prayer for modification of the order to the extent for creation of superannuary report. That was allowed by your lordship. And giving them 6 weeks. My lord, by now 12 weeks has elapsed. My lord, I have.
Yes, Mr.
My lord, so far as I am concerned, my lord, proposal has gone from our side, my lord. that
Yes,
when
handy.
Government.
Handy.
Lord, my lord.
Supernumerary post for the petitioner.
Supernumerary post, yes.
Can you be taken after September? My lord, Mr. D, not earlier, it appeared now. Went up to it.
Dinner.
Number 24.
Lordship, can you have a look on the last order, 5/1/24, my lord?
Lordship, we already been communicated, my lord, we have not received any instruction. We have communicated on my lord, the 10/1/2024.
10/1.
2024.
2024.
Last time, my lord, it was, my lord, listed on 5/1, lordship. The time may be granted, my lord.
What more time? Maybe they are interested to visit Guwahati Bharat.
Maybe, lordship, give me the last chance, my lord. I
Is it
can take
not?
it.
It appears so. Yes, MS Bordula. Maybe they are interested more. Maybe they want to visit perhaps. What more is required to understand? Order has been passed already.
Yes, my lord, almost.
Untying the knots. Real state of affairs, what they are doing with the money. Yes, Mr. Henry.
Lordship, my lord, without my lord, the instruction, I cannot submit anything, my lord. We already been communicated, my lord. Let me give me some more time.
Affidavits are filed by whom? Deputy Commissioner? No,
No.
not yet.
Not. My lord, the
And
file
who are
by,
the
my
other
lord, that the
person?
respond number
PWD, your lordship.
178.
MS Bordulo and MS Mr. Borua.
Yes, my lord.
Last time.
Yes, I am awaiting my instructions also. Your lordship.
And this is a matter under Revenue Department.
But your lordship, the revenue department.
As Gayan has said, we have paid the money.
Yes, but revenue department will also obtain the instruction from the DC office only. Your lordship.
But you are the nodal one.
I have
Deputy
communicated.
Commissioner
Yes, sir.
works under your instruction,
Yes, sir.
under your control. So they are not under your control, it appears so. Matter is regarding acquisition.
Yes.
But the last 10 days time, my lord, can't be given.
Or otherwise we have to see.
But if failing which, my lord, lordship can pass that verse. Any order.
Heard Mr. P.K. Tekal, Learned Counsel for the petitioner, A. Gayan, Learned Central Government Council, CGC for the respondent of 1, 7 and 8. MSN Bordeaux and Standing Council Revenue and Disaster Management Department for the respondent number 2 and Mr. J. Hendrik, Learned Junior Government Advocate Assam for the respondent number 3 and 4 and Mr. P. Nayak, Learned Standing Council PWD for the respondent of 5 and 6. Yes, Mr. Nayak, do you have anything to say?
My lord, now written.
Okay. MS Bordulo, Learned Standing Council Revenue and Disaster Management Department and Mr. Hendrik, Learned Junior Government Advocate Assam. Appearing for the respective respondents have submitted that though after the order dated 5/1/2024, the respective respondents have been communicated from their ends. No instructions have been received by them till date. Full stop. They have, for ends of justice, sought further 10 days time to make endeavor to obtain instructions from the respondents represented by them and to file respective Counter affidavits in deference to the order dated 5/1/2024. Post of having gone through the order dated 5/1/2024 and considering the joint prayers made by MS Bordolo and Mr. Hendik, let the case be listed on 23/2/2024 to enable MS Bordolo and Mr. Hendik to take necessary steps from their ends. Full stop. It is observed that in the event no instructions are placed on the next date of listing, the court may be constrained to call for personal appearance of the concerned respondents.
Deeply obliged.
Obliged.
25. Item 25.
Please, your lordship.
Yes.
Lordship had heard this matter at length on early in December.
This court?
This court. And,
Forgot. I hardly remember.
and lordship, let me,
Regarding appointment of arbitrator, Lordship.
Huh?
Regarding appointment of arbitrator. government
Appointment of arbitrator.
Arbitrator, Lordship, what happened, the government has already sent the proposal to the Ministry of Road and Transport, and they are going to take steps.
A. Burman.
Signed by.
No, who has been proposed?
Yes,
Ah.
name of the, Ashok Kumar Burman.
That has been rejected by the central government. I am more updated than you.
Oh. I don't know, today on morning I have
This is
asked them.
All instruction. In
1612
an earlier case,
1612, Lordship. They have.
because of the direction issued by this court in the three petitions,
Lordship,
thereafter, name of Ashok Burman was proposed by the state government.
yes.
Today, MS Bordolo has submitted, right? The name of Ashok Kumar Burman has been rejected by the central government because he is a retared state government employee.
Retired, that is retired, he's a retired.
So you don't know your stand.
Lordship, they have given.
Get new instructions. Any new name is proposed, MS Bordolo. Then again, we have to consider this repetition like the other one.
Lordship, same order has to be filed.
Huh?
But the department is not aware of this rejection, Lordship. Why? I don't know.
এই ইটো কেছৰ যে
This morning, Lordship, I have.
ইটো
talked with
কেছৰ
them.
যে আছিল ইটো কেছৰ কপিটো
Jalan.
আৰু জালান no
Jalan.
the jalan is okay but this one along with the phrase other one that Ashok Burman's name is rejected. Give a copy to MS Bora also. Okay, we keep it on Thursday. If possible, we will dispose of. Mr.
MK Chaudhary.
MK Chaudhary. I thought that it was typing mistake. I was looking at it. Because MK Chaudhary Learned Counsel. I thought that something is wrong. The Learned Counsel for the petitioner. MS R. Bora Learned Standing Counsel. NHID still repeat koi dibo. List the case on Thursday.
Obliged.
If possible, we will dispose in terms of the earlier judgment and
Jalan.
after taking into account this rejection of Ashok
So
Burman's.
I'll take instruction today itself. I inform them.
Item 26.
26. Yes, Abul Hussain. Abul Hussain and another.
May please, lordship.
Huh?
This is.
May I please, Lordship?
Yes.
Lordship, before starting my line of family, in this case, I am applying for response number 5 million.
5.
Lordship, recently some development happened. We may not no longer in this case, Milord. So I need some instruction. Though
What
we are
kind you need? What kind of order has been challenged?
Lordship, here some
Yes, my
land
lord,
was
and this is-
acquired, Milord.
Land was
Land
acquired.
And response number 5 is the beneficiary of that acquired land. Milord.
Okay. Any affidavit is filed by respondent number 5?
No.
This is by state government.
Who is respondent number 2?
Respondent number 2 is the my lord.
Deputy Commissioner. Milord. Deputy Commissioner Kamrup, my lord.
What happened to your land? It was acquired,
Acquired, my lord, acquired.
acquired
And
by due process.
amount was also sanctioned, my lord. But dispute between two parties, my lord. Claimant is two, my lord. That is the problem.
This is between the private respondent and the petitioner lordship. Land belongs to the private respondents. In the record of rights, their name is there.
This was under the new act.
New act.
New act or which act? Which
No,
act?
the earlier act, my lord, 1960.
What is
19?
1964?
1964 and my lord,
1894.
1894.
1894.
Yes, my lord.
State act lordship, 1964 state act.
1964. If there is dispute between two claimants, what do we have to do?
It is a question of facts. Question of disputed question of
Deputy
facts.
Commissioner is required to send the matter to the court, my lord, civil court, my lord. That is the law, my lord.
You take your instruction in the meantime, otherwise I'll send this to
10 days, my lord.
the court under section 18 perhaps.
18, my lord, 18.
Okay. Mr.
Yes, sir, I'm-
H.R. Ahmed, petition. Mr. Hendrik, revenue.
No, lordship,
And modular. And modular revenue 1. J. Hendrik, Junior Government Advocate, Assam 2, 3 and 4. Mr. M. Mohanto, Land Council for the Husband of 5. And Mr.
6 and 7 lordship.
S.D. Purkas, the Land Council for the Husband number 6 and 7. Mr. A. Day. Deka, Land Council for the Husband number 8. Mr. Mohanto, Land Council for the Husband of 5, has sought listing of the case after a week in order to obtain instruction from the respondent of 5. Full stop. Release the case on side go. Huh? Interim
order is there.
interim or passed shall continue till next.
Obliged, my
Interim.
Item number 27.
May I please, your worship.
In
this case, your worship,
What is this?
lordship matter pertinent to SKDC, your lordship.
Yes, this here.
Yes, lordship. Here, lordship, on last occasion, Learned Council make a prayer for taking inspection. Additional affidavit also. Yes.
Yes. Ramesh Bodu and Mr. Hendrik.
Lordship, my lord, that one parawise comment I have received in that parawise comment, my lord, there is stated that my lord, the petitioner have to submit the NOK certificate.
NOK is here now.
Lordship, my lord, now
You'll submit.
Lordship.
After the MS Bodu,
Yes, your worship. Yes.
should we keep this pending?
Worship may dispose it.
Heard Mr. SI account. Yes. Learned Council for the petitioner and Bodu, Learned Standing Council,
For one.
Revenue and Disaster Management 1. Any finance? Any finance?
Finance. H only has same.
Actually, yeah. Visible and Standing Council, Finance Department for the respond number 2. Mr. J. Hendrik, Learned Junior Government Advocate Assam for the respond number
3, 4 and 5.
3, 4 and 5. Petitioner, change to you, the petitioner. Petitioner father, comma, Bhuladas alias Bholaram. Date of accident 22/11/2017. At 8:30. 8:30 AM. Accident while he was proceeding from Bhokatgaon towards Mikitpatri by riding his motorcycle. Bicycle. And when he reached a place, and at that time, from vehicle, the alias offending vehicle, being registration number AS05F4964, proceeding from the same direction, in a rash and negligent manner. Collided with a bicycle. And as a result of the accident, the father of the petitioner sustained grievous injuries on his person. And he was immediately taken to Shohid Upal Kaur Civil Hospital, Golaghat for treatment. He succumbed to his injuries on 22/11/2017 itself. Postmortem performed at Upal Kaur Civil Hospital, Golaghat. On 22/11/2017. And as per the postmortem examination report, the cause of death was due to coma and shock as a result of brain damage due to head injury sustained by the deceased. Any police case?
Yes. Lordship 22.
Police case, Merapani Police Station, case number 228/2017 under section 279/304A IPC. Any application? Representation 19/2/2022. Next of kin certificate dated 26/9/2022. Recording that the petitioner is the son stroke next of kin of the deceased, Huladas. Register of birth and death. Where is that birth certificate? The date of registration to asset, page 17. Again, लिखी थी पर 5 और पर 5 और पर लिखी थी 7 और लिखी थी वो notice or date to 5 और 7 initial notice or date. हाँ Enquiry. Petitioner will participate.
Yes.
Whatever document available at his disposal will be submitted by him.
Within
few days, we will.
Item 22, I'm being with.
He's coming.
Yes, any progress?
No, the Lordship, kindly, I missed the matter, in fact, I missed the matter.
Okay.
Lordship, kindly give me 2 days time.
Mr. A.I. Within learning council Kidivo, Dina, taking Kidivo, BUV. Who is for response number 3? Response number 3 is what? Mr. HK Das Kidivo, pending council 4, 5, 6, and 7. Mr. Nath has sought listing of the case after 2 weeks in order to enable him to obtain instructions as regards completion or otherwise of the process for creation of supernumerary reports. The prayer made by so is allowed, lease the case after 2 weeks. Okay, lease the case, March. Lease the.
Showing his name and other on the next day again, my friend was also.
Somehow I missed the matter. I'm sorry.
The estimate right to show his name, then.
He'll note down, not date will be given.
Lordship.
Kiman dile?
Lordship.
4th March. I am obliged.
29.
May I please your lord?
Madam,
In this
respondent has
filed
signed
our
affidavit.
Okay. Then everything is complete.
No, no, my lord, they have filed affidavit where we say copy, who may be given 3 weeks time to file the rejoinder, madam.
That will be last, I think.
My lord,
Thereafter, no exchange Anything is required.
No, today case is listed after filing of the affidavit, my lord. We have
Right.
received the copy.
So you will file your reply
File, my lord.
within 3 weeks. Within 3 weeks.
Within not possible, my lord.
3 weeks.
3 weeks, my lord, 3 weeks. I think.
Ah. So we'll post it after 3 weeks.
Yes, I'll do it.
Yes, Mr. After 3 weeks, you are fixing a date. Then everything is complete, we'll proceed for
And final respondent,
final consideration.
final respondent, file affidavit, we have file reply also.
Okay. Mr. K. Sharma. Learned counsel for the petition. Hard, huh? Or judicial, Mr. H. Sharma. Learned additional senior government advocate Assam for the respondent number 1. Mr.
N.K. Sharma, Lord.
N.K. Sharma, learned counsel representing Mr. H.K. Das.
Correspondent number
standing
2 and 3,
counsel
Lord.
GHC for the respondent number 2
And 3, Lord.
3. And Mr.
D. Bora, my lord.
D. Bora, learned counsel for the respondent number 4 to
10.
10. Mr. Sharma, Mr. Lance standing up. GHC has submitted that an affidavit in opposition on behalf of the respondent number 2 and 3 has been filed, has already been filed by serving a copy to the land counsel for the petitioner. So Mr. Sharma, land counsel appearing for the petitioner, has prayed for and is granted 3 weeks time to file and an affidavit in reply to the said affidavit in opposition filed by the respondent number 2 and 3. Full stop. Please the case on after 2 weeks. Motion.
Right.
Deeply obliged, Lord.
Item number 30.
Yeah, so in this case, research respondent is supposed to file the affidavit, also, but not yet filed.
What is the case regarding complaint of allotment of PMAY?
There is a complaint that was lodged before the deputy commissioner in
An
Nagaon, my lord.
inquiry has already been initiated.
No, no inquiry instead also.
Circle officer was supposed to.
Also
actually-
kindly come to page 29 also.
Page 29.
Page 29. No inquiry has been conducted also. That is my grievance also.
My lord,
It has been directed.
direct-
Direct, but
it
not.
is reflected in order dated, my lord, 28/7/2023.
You are the Gram Panchayat president.
Lordship. I have
And you are seeking inquiry.
Lordship, I have received some
Is
complaint.
there any move?
Yes, he's fearing that, man.
Lordship, I have.
There is
received some-
move afoot.
Lordship.
But already over.
Almost.
I think all the panchayats are,
Anyway,
term is over.
Panchayat is over, Lordship. But I.
Term of the panchayat is over.
Lordship.
We can dispose of by directing this.
Lordship can dispose it to make the inquiry as per order dated 26/4/20.
Because since already the additional deputy commissioner has directed
Lordship.
the circle officer
Being revenue
Being
secretary
revenue circle.
to cause an inquiry
Lordship.
and submitted
and to submit a report.
within 10 days.
Your allegation is that inquiry
Not yet
is
com-
not yet completed, resulting into any inquiry report.
Lordship.
So we can close this by directing that to complete the inquiry already directed by this order
Lordship.
and outcome of the inquiry
Maybe.
may be furnished,
Very furnished, Lordship.
informed to the petitioner.
Lordship.
That's all.
No trouble.
Otherwise, your term is over now.
Lordship, time is over.
You
Only to say.
you completed your term as the Gram Panchayat president.
Lordship.
Purpose of this perhaps is different.
There's a reference to that, man, in the pleadings, man, is mentioned over there.
That there is move on the
Yes.
part of the,
Lordship, there-
is it not?
Yes, there is a.
Heart. Mr. N.J. Gogoi. Counsel for the petitioner. Mr. Taldar, you represent whom?
1-3.
Mr. Vijay Taldar, senior counsel, assisted by Mr. P.K. Mari, land counsel for the respondent number 1, 3, 5. Mr. N.K. Debnath, land standing counsel,
For 2, 4, 6 and 7.
Panchayat and Rural Development Department for the respondent number
2, 4, 6 and 7, 1.
2, 4, 6, and 7. Anybody for the private respondents?
No, Lordship.
They were served.
Lordship, notice are not issued to the private respondent.
Okay.
Lordship, what is there?
28/7, 2023 order. The petitioner at the time of filing the writ petition, was serving as the president of Botodroba Hotro Gaon Panchayat. Full stop. It is the case of the petitioner that the petitioner had submitted a representation alleging commission of a number of anomalies in allotment of PMAY houses, etc. in the Gaon Panchayat. Full stop. On receipt of the complaint, the Deputy Commissioner Nagaon why this
26/4/2020.
the additional Deputy Commissioner
Letter dated
Nagaon
Nagaon. Letter dated
O stroke O. The Deputy Commissioner Nagaon by this letter bearing number so and so, Annex 5, page 29, dated 26/4/2023. Directed the circle officer, Dhing Revenue Circle, within bracket the respondent 5, to cause an inquiry and to submit a report within 10 days from 26/4/2023. To stop. Stating that no inquiry was finalized till the date of filing of the writ petition, the petitioner had approached this court by the instant writ petition, seeking inter alia a direction to the respondent authorities to conduct to complete the inquiry and to submit a report as regards the allegations, stroke complaints regarding allotment of PMAY houses and misuse of PMAY fund. And full stop. Para Mr. Taludar and Mr. Devnath have submitted that the term of the panchayat is over and the petitioner is no longer serving as the president of Botodroba Gaon Panchayat. Hotro Gaon Panchayat, full stop. Be that as full stop. They have further submitted that be that as it may. And since an inquiry has already been directed, provide notice, letter dated 26/4/2023, this petition can be disposed of by directing the respondent number 3 and the respondent number 4 to bring the inquiry to complete the inquiry initiated by the notice letter dated 26/4/2023. Mr. Gogoi, Learned Counsel for the petitioner, has agreed to the said submission. In view of the board consensus arrived at by the parties, this court is of the considered view that instead of keeping this petition pending, the same can be disposed of with a direction to the respondent number 3 and the respondent number 5 to complete the inquiry already directed by the notice dated 26/4/2023 as expeditiously as possible. Preferably within a period of 2 months from the date of receipt of a certified copy of this order and submitted from the petitioner at the office of the respondent number 3. Full stop. It is accordingly ordered. Full stop. It is further observed that the outcome of the said inquiry process shall be informed to the petitioner forthwith thereafter. In order to facilitate completion of the inquiry, the petitioner shall submit a certified copy of this order at the office of the respondent number 3.
May it, please,
Oh,
Lordship.
అది too boring, no?
Lordship,
Yes, for the type order, you are asked some correction. Make a mention, we'll try.
Lordship,
Because otherwise I would have seen with, because there are others function, I have to rush.
Lordship, in item number 33, interim sale may be continued.
Okay, interim, 33.
Highly obliged.
Item number 46 also interim order is
46.
issued.
1 minute, 1 minute, 1 minute, 1 minute.
And service is complete, my lord.
43,
Item 46, my lord.
46,
my
you
lord.
are on interim?
Yes, my lord.
Huh?
I am 46, my lord. Item number-
Interim?
Yes, my lord.
Interim আছে যদি হেৰি কৰি দিব, extend কৰি দিব।
Item number 34, my lord.
34,
Interim is till today only, my lord.
okay, interim extend কৰি দিব।
So item number 36.
AK Borua, Learned Counsel for the petitioner is present. List the case after side data. Interim order passed shall continue.
Okay,
Till the next date of listing. Yes, Mr. 49. 39.
Lordship, I beg to mention item.
1 minute.
Oh,
Somebody is
sorry.
submitting.
Sorry, Lordship.
Okay.
Interim order to continue.
Okay.
Lordship, fix a date, Lordship, otherwise.
Let's see. Okay, after a week. Release the case after a week. The interim order passed shall continue till the next date of listing. Item for 39.
31 maybe
30.
checked with the 51, my lord. Same matter, my lord.
What was the returnable rate there?
16-2.
16-2. Okay, on the prayer of Mr. S.C. Viswas, Learned Counsel for the petitioner, release this case on 16-2.
Yes, along with this matter.
Lordship, item number 36, Lordship, interim may be continued. Item number 36, Lordship. Interim is there, Lordship. So.
Okay. Any instruction? 36, anybody? Okay. Run the heard the Learned Counsel for the petitioners, parties, release the case after 2 weeks. You are having interim order?
Yes, Lordship.
Okay. The interim order passed later shall continue till the next date of listing. Yes, Mr. Gustavo.
Madam, 34, your lordship has already passed order. I think lordship has directed to fix a date, madam.
Huh.
I am.
After 2 weeks, you want date? Okay.
As your lordship, madam.
AK Borua, Mr. Learned Counsel for the petitioner, Mr. B. Goswami, Learned Additional Advocate General, Assam. And Mr. C. Borua, Learned Standing Counsel, NHAI, NHIDCL. Hard code you. Release the case on 1-1, 1-2, 1-3, 1-3. Any earlier date? No. Okay. Interim order is there.
Only thing,
Interim.
yes,
Interim
is there, madam. Only thing, if possible, madam, lordship may directly raise it to my name.
Okay. The name of Mr. B. Goswami, Learned Additional Advocate General, Assam, be reflected in the respondent side in the cause list.
Item 44, Lord.
44.
Interim is still today.
Okay. On the prayer of Mr. B. Pusila, Learned Counsel for the petitioner, Mr. M.K. Hussain, Learned Counsel for the petitioner.
Lordship, item 44 for the respondent 10 and 11. I'm appearing for respondent 10 and 11.
Have you filed any affidavit?
Yes.
You want to file affidavit?
Yes.
Tell me.
That's fine, I guess.
Huh? NMS?
Miss P. Bora.
P. Bora, Learned Counsel for the respondent number 10 and 11 are present as sought for by the Learned Counsel for the parties. Release the case after a week. The interim order passed idea shall continue till the next day.
Item number 35 is a fixed matter.
Interim order?
No interim order. Actually, fixed order.
What is the subject matter?
Subject matter regarding
Side you
filling of fees and
35. Yes.
Item number 53, Lordship, I have mentioned.
Interim order?
No, interim order, Lordship. Urgency is there, so kindly matter.
What urgency?
Urgency, we.
You always have urgency. Everywhere.
No, Lordship, whatever we have paid in this petition for not issuing legal error certificate.
Huh?
Not issuing legal error certificate in respect of respondent number 9. Legal error certificate already issued and producing that legal error certificate. Thursday, Lordship.
Persuade the court master not this week.
Very urgent.